All right. Welcome everyone to the first session of our training series on the Illegal Migration Act 2023. Thank you for joining us. ILPA is acutely aware of the need to bring legal practitioners, local authorities and other individuals in frontline roles up to speed on the Act, so it is really good to see so many of you here today. I would like to start by thanking the Greater London Authority for partnering up with ILPA in delivering this session. It is thanks to their support that we are able to deliver the session free of charge. We're really lucky to be joined today by ILPA Legal Director and fantastic tutor Zoe Bantamman. I'll let Zoe introduce herself in a second. I'm just going to start the session with a bit of housekeeping. My name is Clara and I'm the training officer at ILPA. I'll be here throughout today's webinar, so please message me privately if you need anything or have any tech issues. You will have heard that we're recording the webinar. The recording and the training materials will be shared with you after the webinar and will be made available to all on our website and on the Greater London Authority website. Zoe will be answering questions at the end of each section, so please ask questions in the Q&A box or the chat box to this effect. I'll be circulating a short survey for feedback at the end as well, so please fill it out if you have time. And that's it from me. I hope that you enjoyed the webinar today. I'll pass over to Zoe.
Thank you, Clara, and good morning, everyone. It truly amazes me that more than 100 people have joined this training at 10 a.m. to discuss something which I always say is as depressing as the Illegal Migration Act, first thing in the morning and then for several hours thereafter. But I am also really grateful to all of you for making the time to come today. I know that in this virtual room, we have extremely busy legal practitioners, individuals from local authorities, frontline caseworkers who have joined us. Unfortunately, as I was saying, I can't shield you from the Act's rather depressing mechanisms. These are the exact mechanisms that this overview seminar is intended to unearth. The Act is, to be quite frank, built as a snare from which there's little to no room for migrants to be released, and for us as those caseworkers, practitioners, to assist them to be released. As we discuss these mechanisms, I'm sure that you will feel despondent. I taught a 4-hour in-person seminar on this Act on Friday, and I could just see everyone's faces throughout the course of the seminar get more and more despondent. And although I can't see all your faces today, I'm sure that's how you'll feel. And we've definitely felt that way at ILPA since the Illegal Migration Bill was laid on the 7th of March this year, throughout the summer, which we spent in the impossible task of trying to have it amended to mitigate some of its damaging provisions, and were admittedly unsuccessful in doing so since it received royal assent on the 20th of July this year, and now in the period of time in which the Home Office has been planning its implementation. Judicial and also legal practitioner tools for upholding human rights at a domestic level are intended to be limited by this Act, and we'll talk about it further today. But under this Act, lesser used remedies will be required, like applications for a writ of habeas corpus. And in the training I did on Friday, one attendee said, "What is habeas corpus?" And also interim measures indicated by the European Court of Human Rights under Rule 39 of its Rules of Courts. These will be the types of remedies which become increasingly more important under the Illegal Migration Act. I know that there are many people here today who will hope that large parts of this Act are not commenced ever. That's a hope that I share. That large parts of today's seminar will be irrelevant, and my preparation in trying to teach you all about parts of the Act will also become irrelevant, and because those provisions in the Act will be erased from the statute book by a new government, perhaps following the next general election. However, we don't yet have any assurance as to who that government will be, or whether they will indeed seek to repeal the Illegal Migration Act or its most damaging provisions. I'm eagerly awaiting sight of the manifesto commitments from the parties, but without any certainty that repealing the Illegal Migration Act will be one. Therefore, I do think it's vitally important that you know what is in the Illegal Migration Act, and more importantly, that you know how it does and how it could affect migrants with whom you're working with on a quotidian basis. Insofar as we go beyond today, what's already been commenced, this training, as I said, is contingency training. However, it's not all posturing by this government. If the government does intend to commence the Section 2 duty in this Act, and I'll explain what that is, it can lay regulations in Parliament very quickly at speed in order to commence parts of this Act. And if it did so, as it did with the first set of commencement regulations, which were laid on the 11th of September this year and brought provisions into force on the 28th of September at speed, then that could be really damaging for the frontline practitioners and caseworkers, because it's really difficult to wrap your head around all of the sections of the Act in, let's say, 17 days. So that's why we're here today. We realize it's quite a difficult task to ask you to come to grips with 69 or so sections of the Act and 2 schedules, and no matter how much we try to do so today, we're not going to get through all of those sections and schedules in the course of a 3-hour seminar. However, this is only the beginning of the seminar series. The incredible Alison Pickup, as you might have all seen, is due to provide the next seminar in this series, which will be free training on the entry, settlement and citizenship provisions, which have already come into force, and I'll touch briefly on them today, but I would encourage you to sign up to that training course, which is next Wednesday. And before the end of the year, we're hoping to have further free training sessions on the detention provisions in this Act. Because so much of the Act is not yet in force, and there's little guidance, rules, regulations that have been laid or published, we can't really speak to how many of the provisions in this Act will be implemented in practice. And so what I'm trying to provide today is just a really headline overview of what the Act itself says and the little that I know about how it might be implemented in practice. But some of this is speculation, and some of this is based on what we've seen or heard in the sector and from the Home Office. All right, so just moving directly on to the agenda. As Clara was saying, we're going to start with a little mini overview of the Act, where I'm going to lecture at everyone for a little bit just to explain who's targeted by the Act, what happens to people who are targeted at a very headline basic level, and what's in force so far, as those are the 3 most important things. And then I intend to do sort of section by section breakdown of the Act, because I do think it's important that you understand what's in there. And each of those will be followed by a Q&A. As a further headline point, just before we move on, I want to let everyone know that if they haven't already looked at the Act is incredibly complex. As I was saying, today is just the beginning of the training, the beginning of the discussion about the Act. It's by no means the end. If you leave today and you feel even a little bit more confident about what the Act is intending to do or what's contained in the Act, then I'll feel that this seminar today was a success. I don't expect you to have a comprehensive understanding or an in-depth knowledge of all of the sections of the Act and its schedules by the end of this seminar. For the legal practitioners in the room, I would also say that there is no replacement for looking at the actual text of the Act. While I have tried to summarize in the seminar today some of what the sections say, I encourage you to look at the actual text and also to attend our more in-depth training on the various sections of the Act. I'm certainly not omniscient, and I'm no expert in all of the areas of the law that this Act covers. I've definitely made my own mistakes in trying to understand its complexity from the point of the bill's introduction on the 7th of March to now. But I'm here so that you can learn from my mistakes rather than repeat them yourself. If I was still in practice as a barrister, my greatest fear would definitely be looking at the Act, the text of it, trying to read it and navigate it only when first instructed in a case in which someone is subject to the provisions of the Illegal Migration Act. And that may particularly be the case for some frontline caseworkers who might not be working on entry, settlement and citizenship cases or on detention. And so whilst these provisions have already come into force, haven't yet looked at the text of the Act. But knowing what is in the Act is the first step, so that it's not some unknowable behemoth that's just looming above all of us like a dark cloud. And to that end, we are going to go through section by section through the Act just so that you know what is there. All right, so let's move on. Who does the Act target? This is the most key question in the entire Illegal Migration Act. And the answer is that it doesn't just target those arriving by small boats. Don't buy into that aspect of the government's rhetoric. It doesn't even just apply to those who take dangerous journeys. It applies to people, all people, including people who, through no fault of their own, were trafficked into the UK if they meet the 4 conditions which are laid out in Section 2 of the Act. The first condition is that the person entered the UK by means that the government deems irregular. And these are listed in Section 2. I've given a couple of the examples from Section 2, such as requiring entry clearance or an electronic travel authorization, but arriving without it. But also obtaining leave to enter by deception is one example that's given. It's important to be very aware of all of the different ways in which someone could come within this irregular entry or arrival under the Act. The second condition is that the person entered or arrived in the UK on or after the day the Act was passed. Interestingly, I have been interpreting this as passed into law and taking this as the 20th of July 2023, the date of royal assent. However, technically, the bill was approved by the House of Lords in the early hours of the 18th of July 2023. I remember staying up for that horrible vote. All I can say in favor of my interpretation is that Lord Murray, when he introduced this amendment in response Lord Carlisle's amendment on retrospectivity, made clear that their intention was to apply the duty to remove from people who entered the UK unlawfully from the date of this bill's royal assent. And you can find that in Hansard debates on the 12th of July 2023. So let's assume for the purposes of this seminar, and I hope that I'm right, that the day on which the Act passed is the 20th of July 2023 for interpretation of that second condition. The third condition is that the person did not come directly to the UK from a country in which the person's life and liberty were threatened by reason of their race, religion, nationality, membership of a particular social group, or political opinion. As everyone I'm sure knows, these are the 5 Refugee Convention reasons. And the Act goes on to further define what's meant by this, not coming directly, and says that if a person passed through or stopped in a country where their life and liberty were not so threatened, they would meet that condition. The fourth condition is that the person requires leave to enter or remain and does not have it. If there's anything you want to memorize from this Act, I would say it would be these 4 conditions. For every person entering or on or after the 7th of March 2023 for accommodation and entry and settlement and citizenship provisions, I just wanted to flag there is that different date of the 7th of March rather than the date the bill passed, but we'll talk about that a little bit more as we go on. Okay, cherry picking. So under this Act, it's really important to recognize what the overall impact is in terms of who is granted protection in the UK. The government of the day under this Act can cherry pick who can be granted refuge by choosing who is resettled and choosing which resettlement routes are capped. We all know there's no asylum entry clearance or asylum electronic travel authorization, so there's no option except for searching for an available safe and legal route, such as the nationality-specific ones for Ukraine, Afghanistan, and Hong Kong, or the general resettlement routes. What this Act does is it also sets an annual cap, a maximum on the number of people who can come to the UK on safe and legal routes, and that's contained in Section 60 of the Act. There's now an ongoing consultation by the Home Office with local authorities that's running from the 20th of October 2023. And in the consultation document, which I've linked in the slide there, the government has said that the cap will include the main safe and legal routes used by vulnerable and at-risk people, including the UKRS, the Afghan Citizens Resettlement Scheme, and the Community Sponsorship Scheme. But it does not include the Afghan Relocation and Assistance Policy, the Hong Hong Kong British National Overseas route or the mandate scheme. By placing a cap on such routes, the government will effectively have carte blanche through these regulations, and it seems in the consultation it's already pre-decided which routes will come within this cap to determine which nationalities, cohorts, groups of people have the right to protection in the UK. Unsurprisingly, Hong Kong, Ukraine routes, and Afghans who worked for with the UK government, as we said, and are eligible for ARAP are exempted from the cap. However, I just wanted to flag that the Afghan Citizen Resettlement Scheme Pathway 3, which was also meant to offer a route to settlement to those who are particularly vulnerable, such as women and girls and members of minority groups, well, it is to be capped, even though the government made a commitment in August 2021 following Operation Pitting to allow them to come under Pathway 3 of the ACRS. Stage 2 of that pathway has yet to be commenced. In any case, it seems to me quite a difficult task to ask local authorities to determine how availability in October 2023 translates to capacity for an annual cap in 2025, or how the Home Office intends to decipher that from the local authorities' current capacity. But as we all know, I don't write Home Office policy. However, of course, the Act sets out that there are sets out no new routes to safety in the UK. So while a report under Section 61 of the Act has to be laid by the 20th of January next year, it may only contain details of current safe and legal routes if there are no proposed additional safe and legal routes. And just to really demonstrate what this cherry picking means, I think it's helpful to look at how many people are cherry picked. And the answer is very few. According to the Home Office's own statistics, of the 22,648 people granted in the year ending March 2023, only 4,414 were resettled. So that constitutes 19.5%. Under this Act, children might continue to be granted discretionary leave, and we'll come on to this, but the large figure here, nearly 80% of individuals recognized as refugees or granted humanitarian protection, would fall away under this Act. It's really difficult to reconcile this with the government's self-proclaimed world-leading generosity. It must also be said, and I'll say it time and time again, who's going to be penalized in all of this, because there will be division and differentiation on socioeconomic lines. For example, I'm sure everyone remembers when Priti Patel last year said in relation to the Rwandan agreement that she had signed, access to the UK's asylum system should be based on need, not on the ability to pay people smugglers. The opposite is true. These measures in the Illegal Migration Act will obstruct access to the domestic asylum process to poor refugees and for those who have no bespoke route on the basis of their nationality. The poorest refugee cannot fly directly to Heathrow from the country in which their life and liberty is threatened, if there are even any flights available, or come here on routes such as a student or as a worker before claiming asylum. They may be entirely unaware of our laws and unable to wait in another country in the hopes that they're going to be one of these few who are cherry-picked. I think it's also important just to say at this juncture that such laws as this, the Illegal Migration Act, do not remove the UK's international legal obligation or the international legal right to asylum. They don't alter the fact that a person is a refugee if they meet the definition in Article 1A2 of the Refugee Convention. All this Act does is allow the government to fail to recognise that such people are in fact refugees. Just moving on to cherry picking and capping, I think it's also interesting to note that very few people come to the UK on capped routes, just over 1,200 in the past year. And yet on the cherry picked routes for certain nationalities, we can see that the numbers reach hundreds of thousands, and these will remain uncapped. So what happens to people who arrive in the UK but who are not cherry picked? Well, like this interlinking chain with lock after lock, by design, the Illegal Migration Act is intended to lock individuals by its statutory provisions so that, and this is at risk, I say, of oversimplifying the Illegal Migration Act, individuals are locked out of asylum and protection, locked in indefinite limbo, locked out of lawful status and citizenship, locked in detention, and locked out of recovery as in support as victims of trafficking and modern slavery. And throughout the rest of today, what I want to do is to discuss some of the nuances of these locks, and they're definitely going to be covered in more depth as well in the rest of our seminar series. Before we turn to some of that nitty-gritty, I think it might be helpful to just ground ourselves very briefly in a hypothetical case study that I've put together. And throughout the course of the seminar, what I think might be helpful to do is to turn back to this case study and to think about the implications of the Act for Rafi. So Rafi is detained in Harmonsworth Immigration Removal Centre. And let's suppose for the purposes of this case study that Section 2 of the Legal Migration Act has come into effect. And so there's now a duty on the Home Office to make arrangements for removal of people who come within those 4 conditions in Section 2. So Rafi arrives in the UK on the 1st of January 2024, next year, on a small boat. He was screened at Manston on that same day that he arrived. A few hours after his arrival. He didn't have any legal advice before the screening. He didn't understand what was happening. He wanted to ask, he was asked if he wanted to make, a human rights or protection claim in his screening interview. And he didn't really understand what that meant, but let's say he said that he was scared of the Taliban back home and that he has family members in the UK. The same day, the 1st of January 2024, so same day he got off the small boat, same day that he's screened, he receives a removal notice. And it says that the Home Office is planning to remove him to Rwanda and that he has 8 days, beginning with the date that he received the removal notice, to make a suspensive claim. I'll explain what a suspensive claim is. It also says that any protection or human rights claim he makes would be inadmissible. He sees a legal aid advisor on the 4th of January 2024, who attended a detained duty advice scheme. So that's a surgery, the 30 minutes of free advice that's run in immigration removal centers, and he only sees the person remotely. But then he's told by the immigration removal center the next day that actually the advisor he saw has no capacity to take on his case. I think this case of Rafi might be the exact kind of case that you're likely to see in practice. I think the vast number of people who will be greatly affected by the Illegal Migration Act will be in cases like this. They won't be people, they won't be European nationals. They're unlikely to be Swiss nationals. They might be Albanian nationals, and we'll get on to that, but they're likely to be from other nationalities, including nationalities with high grant rates for asylum and protection currently, as we saw in the figures previously. In the case study, it's not clear whether Rafi is a child or an adult, and that's on purpose, just so that we can talk about some of the nuances and differences for children and adults under the Act. And I have to say, I don't know yet what the Home Office's intentions are for implementing this Act for individuals that they accept to be children or those who are age disputed. I think it's still very unclear at the moment how they're going to be treated under the Act. I think that from what we know and the instructions that can be taken regarding his country of origin, it seems likely to be Afghanistan. And I think Rafi is exactly the kind of person who may have had no option but to flee his country of origin, who may have been unable to wait for safe and legal routes like ACRS Pathway 3 to open up and be operational. He may have fled to Pakistan, where they want him to leave by the 1st of November 2023 if he's undocumented, and he might continue to flee until he reaches the UK. This case study is based on how the Home Office might implement the Illegal Migration Act. So a short screening interview could take place following encountering a person, and a removal notice could be served the same day as a screening interview. Although in my view, a person is entitled to legal advice in relation to making an asylum claim prior to the screening interview, it seems like there's unlikely to be much of a chance that Rafi will have access to legal advice before the screening interview. And I think this is likely to be the case for many people who are processed at Manston, because there is no detained duty advice There is no duty advisor at all there. And so it's unlikely that they'll be able to find a legal aid advisor who's there to provide free advice before they have to go through a screening interview. And I think we're all well aware on this call of the capacity issues of immigration and asylum legal aid practitioners in the legal aid crisis. I think it's also important to note that the screening interview is quite crucial, as you can see from this example already. It's likely that from the screening interview will flow a number of important decisions the Home Office makes, whether the Home Secretary will grant bail and release Rafi into the community, or whether, as in Rafi's case, he is held in detention if there's sufficient space in the detention estate, whether Rafi meets the 4 conditions in Section 2 that we just went through. Obviously, the Home Secretary believes he does in this case because he served with a removal notice. What countries are listed on the removal notice? In this case, Rwanda is listed. Whether Rafi intends to make a human rights or protection claim regarding Afghanistan, and whether such a claim is inadmissible. And we can see in this case, the Home Secretary has decided it would be inadmissible. It's unclear still, I think, whether a protection or human rights claim will be recorded as being made at the point in the interview. And I can't answer that question, so please don't ask me. We'll just have to wait to see what the Home Office does. But also other important decisions like the suitability of accommodation and trafficking indicators, vulnerability of Rafi, all of these things are likely to be things that will be assessed in part or in whole on the basis of the screening interview. And so, as I said, I'd just like you to keep Rafi in mind as we're moving forward today in discussing the Act. All right, what's in force so far? So this is the second point in the mini overview. At this point, the vast majority of the Act has not been commenced. And so I don't want to be here fear-mongering and make you think that you need to go away and advise on every single provision of the Act because it's all in force now. That's not the case. And so I think it would be helpful to be really crystal clear about what is in force so far, but also to be clear about what is retrospective. The government, as I'm sure many of you know, is waiting for the decision of the UK Supreme Court in the Rwanda litigation, and the hearing of that took place from the 9th to the 11th of October. The outcome of that hearing is quite vital to the UK's interpretation of whether Rwanda is a safe third country or whether removal would breach Article 3 of the European Convention on Human Rights. And thus, it's relevant to the Act's removal of individuals to Rwanda because that is the only country with which the UK has a third country removal agreement at this time. I imagine that the Supreme Court is not going to delay its decision in that case. And on the basis of what Lord Reid said of taking a similar amount of time to the High Court and Court of Appeal, we're expecting the Supreme Court to hand down its decision before the end of its Michaelmas term, so before Christmas. And I think a lot of us here at ILPA are mentally preparing for Christmas to be ruined, depending on the decision and the reaction of the government in the lead up to election season next year. If civil servants are having their leave cancelled this winter, which I saw recent reports of, then that may signal that there's also a really busy winter ahead for the rest of us who support individuals in the migrant community. There have been some rumors in the paper, I should add, about a flight planned for the 24th of February 2023, which doesn't seem that far away. It may only be that individuals on those flights are people who are inadmissible under the inadmissibility regimes in the immigration rules, or the one that's contained or brought into force by the Nationality and Borders Act last year, rather than the Illegal Migration Act. So we don't know whether any people who are targeted by the Illegal Migration Act will in fact be on the Rwanda flight next February, if it takes place then. I think it's also important to note that the Illegal Migration Act isn't all about Rwanda. And in fact, Rwanda is just one country listed in the schedule. We're all focused on Rwanda, not just because of the Rwanda litigation, but because, as I say, it is the only country at present with which the UK has a third country removals agreement. Taking Rwanda out of the schedule might go some way to resolving the problem, but the UK government could also negotiate a third country removal agreement with other third countries, and there have been reports of them negotiating with other African countries in relation to a removal agreement. I haven't heard of any being decided and certainly not seen any agreements signed and published. But the Act also relates to, for example, Albanians being removed to Albania, and it creates new processes for that, which make it quite difficult to challenge removal in those circumstances. And I'll explain what I mean by that as we move on. But I think worst case scenario, we need to think about and prepare for the fact that the Illegal Migration Act could be commenced. And it really depends on whether the government wants to pick a fight with Strasbourg. Clearly, we've all seen them gear up for a fight in the papers with the Council of Europe and the European Court of Human Rights. So we'll have to see whether that affects commencement at all. But let's actually talk about what's commenced so far and where you can find the commencement provisions. So from Section 68 of the Act, the following provisions came into force on the 20th of July, 2023, sections 30 to 37, 52, 63 to 67, this section, so section 68 and section 69. The key sections of those that I would focus on are section 52, which makes all judges of the first tier tribunal judges of the upper tribunal. And I keep asking upper tribunal judges how they feel about that. And also sections 30 to 37 on entry, settlement, and citizenship. It is really crucial to note that these provisions, sections 30 to 37, are retrospective. So although there was some discussion when the Act was passed that the government got rid of its retrospectivity, not quite. It kept some retrospective provisions in the Act, and certainly it's important to note that the Act affects, as I said, people arriving since the 20th of July. So even if those other sections, which are not retrospective, the government thinks, if they ever come into effect, they affect people who arrive on or after the 20th of July. And so they need to be told about that potential outcome when you're advising them as well. So crucially, sections 30 to 37, as I said, are retrospective. And by that, I mean they affect anyone who meets the 4 conditions of section 2, but instead of referring to the 20th of July 2023 date, referring to the 7th of March 2023 date. So that's the date that the bill was introduced to Parliament. And so anyone arriving on or after that date and meeting the other 3 conditions, well, they're banned from entry clearance, electronic travel authorizations, leave to enter, leave to remain, settlement, and citizenship, except with very limited exceptions. And I'll talk about what those exceptions are in a bit, but I think it's just helpful to have an overview of everything that's been commenced. The Act also commenced on the 20th of July 2023, many provisions that are listed in section 68.4, but just for the purposes of making regulations. Then we have the first set of commencement regulations, which were laid on the 11th of September and brought a number of provisions into force on the 28th of September. So section 12 is quite important. It's about the length of detention, and it's intended to overturn the Hardeal Singh principle that it's for the court to determine whether the length of detention is reasonable and that the power should not be exercised if it's apparent that removal will not take place within a reasonable period of time. So it's intended to overturn that principle. Instead, what's supposed to happen is that the Home Secretary is to decide what's, in her opinion, reasonably necessary. And we'll have to see whether the courts interpret this against an objective standard of what is necessary, or whether it will be down to her subjective view. Luckily, we have some training planned I mentioned on the powers of detention, which will hopefully cover this in much greater depth. Section 12 also permits detention regardless of whether there is anything that for the time being prevents their removal or deportation. And as we know from the Supreme Court case of ILPA, the Hardeal Singh principles, which this section 12, seeks to overturn, they only do what Article 5 of the European Convention on Human Rights, which is the right to liberty, requires. They require that the power to detain is exercised reasonably and for the prescribed purpose of facilitating deportation. It is this objective approach of the court which reviews the evidence available at the time that removes any question that the period of detention can be viewed as arbitrary in terms of Article 5 of the European Convention on Human Rights. Additionally, Article 5.1 of the European Convention on Human Rights contains an exhaustive list of cases in which a person may be deprived of their liberty, which include in Article 5.1f of a person against whom action is being taken with a view to deportation or extradition. But as we can see from this third sub-bullet point, Section 12 permits, if the Home Secretary does not consider that removal will be carried out within a reasonable period of time, detention beyond this, for such further period as, in her opinion, is reasonably necessary to enable arrangements to be made for the person's release, as the Home Secretary considers appropriate. And this is highly problematic if bail accommodation cannot be found. I know that bail for immigration detainees, and I'm sure others are highly interested in this aspect of Section 12, and BID, for example, intervened in the Strasbourg case of ASK in UK on this specific point. So what are a few key problems with Section 12? Importantly, it applies to all forms of detention, not just people who have arrived irregularly. So it's not about people who are targeted by the Illegal Migration Act, and I think that's why it could be commenced separately from Section 2. It applies to anyone who is detained. So if, for example, someone here on a family visa, on a work visa, overstays that leave and is subject to detention, then regarding the period of detention, Section 12 does apply to them. If it achieves its intended purpose, then Section 12 will also mean that the Home Office can continue to detain people where, for example, they're not pursuing removal diligently. As we were saying in relation to that grace period, it seems to confer much more discretion than the limited grace period that the UK courts have accepted. And the Hardy-Olsing principles, as we say, only do what Article 5 requires. So this essentially sets the UK up for litigation in the European Court of Human Rights regarding the compliance of Section 12 with Article 5. Importantly, and I should say here, neither Section 11 of the Act nor Section 13 have yet been brought into force. And Section 11 increases the powers of detention, and Section 13 removes judicial scrutiny of that detention, particularly in the first 28 days of detention. So what we have here is Section 12 brought into force, which affects the period of detention. Other things that have been brought into force by the same set of regulations on the 28th of September are Section 15 and also certain paragraphs which are contained in Schedule 2. And these relate to electronic devices, and they essentially mean that we can expect regulations on retaining electronic devices to be made soon for their search, seizure, and access to that information, on when they will be retained and not returned, when electronic devices contain legal privileged information that can be seized, and the extension of these powers beyond immigration officers to external contractors. Section 62, I'm just gonna, is not actually on that slide, but has also been brought into force, and that relates to damage to a person's credibility where a device has been found on them or appears to have been in their possession, and they don't provide access when they're asked to do so by an immigration officer. And so that Section 62 works with Section 15, which is on this slide, in order to make it quite difficult for people who refuse permission and refuse access to their electronic devices. Section 59 is only brought into force for the purposes of making regulations. So Section 59 contains a list of safe countries in Section 80AA of the 2002 Act, and these are the EEA states, Switzerland and Albania. And what the power does is it allows a Home Secretary to add or remove countries from that list. It may be because they have another agreement or they think another country should be considered safe and they want to add it to that list. It's really difficult to know what the Home Secretary is thinking because nothing has been said or published about it at this point. Section 60 and 61 we've already covered are the cap on safe and legal routes and the report on safe of legal routes. All right. So moving on to actually, maybe, Clara, are there some questions? Shall we take some questions on commencement?
some quick questions for you. I think someone asked if someone comes as a visitor and claims asylum at the airport, is it considered illegal entry by deception?
Tariq, I think it would really quite depend on what the person had said when they were making their application as a visitor. And so what the Act refers to is where a person has been granted leave to enter, obtained by deception. And so in the circumstance that you're talking about, this person has yet to be granted leave to enter, obtained by deception. But if, for example, someone comes in as a student, as a visitor, and is granted leave at the border, let's say they just walk right through the e-passport gates with electronic travel authorization in the future, then it could be the case that they would have been considered to obtain it by deception, depending on what they said in their visitor application. And as you know, as I'm sure many on this call know, there is a genuineness requirement to both visitors and to students and workers. So it's something to bear in mind.
Thank you. And there's another question from Agnes, although I think you might have covered that.
Yeah, I'm trying to figure out how to move backwards in my slides. I have figured it out. Sorry, I'm the least tech savvy person, but I think, Agnes, your answer is right here in section 68.3, which is contained in the Illegal Migration Act itself. So don't look to the commencement regulations.
Thank you. There's also a question from Gary regarding a case of 2 people being arrested and prosecuted in Cheshire, and whether that comes under the Act or not, but I'm not sure if you're familiar with that case.
So Gary, I think it might be helpful to have a think. Now I've opened. That have I ruined the slides?
Don't worry, I think it's now just not on full screen, but apart from that.
Okay. Okay, there we go. Gary, I think it's important to differentiate between the Illegal Migration Act and the Nationality and Borders Act 2022. The Nationality and Borders Act 2022 introduced a large number of new offences for entry to the UK. The Illegal Migration Act, on the whole, doesn't concentrate on such offences such as making arrival to the UK itself an offence. And so it's likely to be the case that article, which I haven't read because I try not to read the Daily Mail personally, whether that relates to an offence under the Nationality and Borders Act, which amended previous pieces of legislation.
Thank you. There's a few more questions. Let me know how we're doing for time. Someone would like to clarify again what the 20th of July date applies to versus the 7th of March date.
Really good question, Una. It is quite complex. So the 20th of July 2023 date, which is my interpretation of it, I don't know if other people have different interpretations on what is meant by past, but the 20th of July 2023 date would apply to all of the removal aspects of the Act. So section 2, I think it's also used in 5 and 6, I believe. However, the 7th of March 2023 date is only used in a few places in the Act, and those are in relation to entry, settlement, and citizenship. And so you'll find that in sections 30 and 31 of the Act, and also in relation to unaccompanied children, which we'll come on to in their accommodation, which uses the 7th of March date. Otherwise, everything in the Act applies the 20th of July 2023 date, but we'll talk about in a few moments how that might change.
Thank you. Do you have more time for questions, or I think maybe we can leave some as well for the end? But there was a follow-up question from Tariq asking if it wouldn't be a red flag for refusal to declare your intent to claim asylum on arrival for an application for visitor visa.
Yeah, that's really helpful, Tariq. Obviously, people's circumstances have changed. I'm not saying that the person makes a visit application on the basis that they intend to claim asylum in the UK. As I said at the very outset, we all know very well there is no entry clearance application and no electronic travel authorization which a person can make to claim asylum in the UK. The question is whether they have been deceptive in what they've said. And so that is whether they're intending to knowingly mislead the Home Office and what they've said. And so I think you would need to take a really good look at what they have said in the documents they've submitted, representations they make, and things they say in interview to know whether they have in fact exercised deception. Anyone who's done any deception cases in the past, like Tier 1 General or other ones, will know that deception is often quite a long and lengthy process to challenge as well. Okay, Juliet, just to touch on that really quickly, I can see your question on did not come directly. Where is that defined in the Act? You can find the definition in Section 2 of the Act. Section 2, 5 says, for the purposes of subsection 4, a person is not to be taken to have come directly from the UK, from a country in which their life and liberty were threatened. As mentioned in that subsection, if in coming from such a country, they passed through or stopped in another country outside the United Kingdom where their life and liberty were not so threatened. Dominic, I don't know the answer to your question off the top of your head, potentially not at all. But I think, again, the Nationality and Borders Act has affected the definitions of entry and arrival in certain respects in immigration law. And so I would need to take a closer look at that. If someone accepts a job offer in their EU country of origin and enters the UK with a normal EU passport, then at arrival ID is taken and the person is forced, will this person be considered and not? Julia, I don't think that relates to what we've covered thus far, so maybe we leave that one for now. And we move on to the next part of the seminar, which is to look at the introduction and the asylum ban provisions in the Illegal Migration Act. So right here, I'm hoping it will be familiar to those of you who have opened the Illegal Migration Act before, but you can see the list of the sections in this first part. So there's the introduction, and then there are the sections under the duty to make arrangements for removal. Really important to look at the introduction to the Act. And that's contained in Section 1, and I harped on and on about it throughout the passage of the Illegal Migration Bill in Parliament. What is the Act's purpose? And in one word, removal. It's designed to remove certain people from the UK, and all of its provisions and any secondary legislation made under it must be read and given effect to achieve this purpose. You can see that in Section 1.1 read with Section 1.3. Well, what then about the Human Rights Act? Unfortunately, the courts are limited in their ability to use the Human Rights Act to protect rights. The Illegal Migration Act disapplies Section 3 of the Human Rights Act. Instead of reading the Illegal Migration Act and giving effect to it in a way that is compatible with the rights in the European Convention on Human Rights, it is to be read and given effect to require the removal of certain people from the UK. This failure to make provision for the courts to interpret this piece of legislation in line with convention rights seems bound to result in increased declarations of incompatibility under Section 4 of the Human Rights Act, with increased need for remedial regulations, creating further work for an already busy Parliament. If an incompatibility is found and it's not remedied, then there are likely to be more cases brought against and lost by the UK in Strasbourg for breach of convention rights. The UK will also remain responsible for any of these breaches, and it will have to face the damage to its human rights record and its international reputation. Interestingly, on its very face of the bill, the Home Secretary admitted that she was unable to say its provisions are compatible with the rights to be found in the European Convention on Human Rights. Therefore, in accordance with the purpose for Section 19 of the Human Rights Act 1998, parliamentary scrutiny of the bill should have been intense. If anyone was watching how quickly the bill passed through Parliament and the limited scrutiny therein, they'll know it was not intense. It could not have been intense on the basis of that time frame. However, interestingly, in response to an amendment that was tabled by Baroness Chakrabarti in the House of Lords, the government stated that the bill, as it then was, and you can see it under 1A here, does not require any act or omission that conflicts with the obligations of the UK under the European Convention on Human Rights or the other listed instruments here, which are the UN conventions relating to statelessness, the UN Convention, the Refugee Convention, the UN Convention on the Rights of the Child, and the Council of Europe Convention against Trafficking. And then we come to the rest of the provisions under the asylum ban heading. And so I think it's maybe helpful to go through them in a little bit more detail, because I rushed through them slightly in the broad overview and there were some questions arising. So Section 2. What does Section 2 do? It places a blanket duty with very limited exceptions on the Home Secretary to remove people who have entered or arrived in the UK illegally on or after the Act passed and did not come directly, as we were discussing, from a country in which their life and liberty were threatened for a Refugee Convention reason. Section 3 then does something that's quite helpful and that we would hope any new government would do, which is it allows the Home Secretary to change the date, which is specified in sections 2, 5, and 6, the day on which this act is passed, to a later date in regulations. And so, for example, if we have a new Home Secretary under a new government who wishes to stop the effect the 20th of July 2023, or as it's stated in the statute, the date on which this act is passed can be moved forward to a future date, let's say some date in 2026, after a new government will have had time to pass their own piece of legislation repealing the Illegal Migration Act. And so that's a section that we hope a new government will use. It might also be the case that this government, if they find that their plan is unworkable and they do commence the provisions, need to move the date forward. Section 4 then does something to the Section 2 duty. As I said, Section 2 is a blanket duty, but what Section 4 does is it makes that duty discretionary and only exercisable in certain circumstances, which are detailed in the Act, for unaccompanied children, which are also defined in that section, until they turn 18. And then to give the Home Secretary the power to make other exceptions to the duty. So, for example, she could accept all people of a certain nationality. She could say all Afghans are not subject to the duty in Section 2. She could also say all victims of trafficking and modern slavery are not subject to the duty to make arrangements for their removal in Section 2. So far, this power to make other exceptions to the duty to make arrangements for removal has not yet been used. But again, there's possibility for future advocacy in relation to it if there was a government that was interested. Section 5 then does something which is quite crucial. People on this call might be aware of the current inadmissibility regime that is in place for asylum claims, and there's one under the immigration rules, and that's the subject of the Rwanda litigation at the moment. Then that was removed by the Nationality and Borders Act, which introduced the Section 80B inadmissibility regime, and I won't go into detail in it at the moment, only to say that Section 5 of the Illegal Migration Act introduces a third inadmissibility regime. So what it does is, instead of saying you can get out of inadmissibility in certain circumstances or leave discretion for the Home Secretary, what Section 5 aims to do is to create an obligation on the Home Secretary. She must declare as inadmissible any protection or human rights claim relating to a person's country of nationality or identity. And this is quite crucial, and I'll explain later on why it's crucial that the human rights claim is in relation to their country of nationality or identity. So any claim they make, any protection or human rights claim in that manner, is for a person who's targeted by the duty to removal. So that's a person who comes within the 4 conditions in Section 2, that is permanently inadmissible. And she doesn't have a choice as to whether to declare it permanently inadmissible or not. She must. And then, as is currently the case, there is no right of appeal against inadmissibility. We then have Section 6, and it works with Section 5 and also with Section 2. So what it does is it aims to ensure that where the duty to remove applies to a person, sorry, I didn't switch a slide. No. People have to be removed as soon as is reasonably practicable from the UK. So it puts a time limit on it. And for unaccompanied children, this would be when they turn 18. So for unaccompanied children, they have this power to become duty to remove hanging over their head until their 18th birthday. It then stipulates in Section 6 where people can be removed to. And so it's quite a crucial section to wrap your head around. EEA, Swiss, and Albanian nationals can be removed to their country of nationality and identity unless exceptional circumstances apply. And we're talking about exceptional circumstances of the kind of Article 15 derogations from the European Convention on Human Rights. Or they can be removed to a designated third country, which is listed in Schedule 1 to the Act. Non-EEA, non-Swiss, non-Albanian nationals can only be removed to Schedule 1 countries. And so there's a really important distinction at the heart of what someone's country of nationality and identity is. Section 7 then lays out the procedure for the Home Secretary to amend the list in Schedule 1 on the basis that, in general, a country or territory or part of it is safe. Section 8 requires a removal notice to be given explaining the planned country or territory of removal. So as we know, in Rafi's case, he received such a Section 8 written removal notice regarding his removal to Rwanda, and it listed Rwanda as the planned country or territory of removal. The removal notice must also lay out the right to make a suspensive claim and the claim period for any suspensive claim. It allows the Home Secretary as well, hidden in it at the end, to also force private individuals and companies to make removal arrangements for people to help enforce their removal. Section 9 then provides access to Section 4 asylum support under the 1999 Act for people whose claims are inadmissible. Why then will this act be a practical failure? And I know that we said it throughout the passage of the act, but also the Labour Party and others have explained the practical side of it. It simply won't work. So what this act does is it removes the asylum backlog only by refusing to consider the claims. The backlog of people will still be there. They will remain. The permanent inadmissibility it introduces will make everyone, nearly everyone, the Act targets from outside the EEA, Switzerland and Albania unremovable in reality, and then they can only be removed, as I said, to one of the 57 countries listed in Schedule 1 to the Act. As we know, Rwanda is the only country with a third country removal agreement, and it cannot possibly accept the likely hundreds of thousands of people, if not more, affected by this permanent inadmissibility. Even if the people who arrive here are inadmissible, don't have meritorious asylum claims or protection human rights claims in relation to their country of nationality and identity, they cannot be removed to their country of nationality and identity unless they're EEA, Swiss, or Albanian, because the Home Office is not considering their claims. So the Home Office cannot know if that country is safe for them when they're claiming that they would face persecution there or breach of their human rights. So the ultimate impact is we have this large and permanent population of people who are living in limbo in the UK at public expense for the rest of their lives, without any hope, of course, of securing lawful status. So if we go back to the case study of Rafi, what's the impact of the asylum ban for Rafi? Does anyone have any ideas? I think we have do we have the chat open to participants, Clara?
Yes, we have the chat open, and people can also request to talk if they want to, if they prefer.
Great. So here's the case study again. And having gone through that asylum ban, oh, the chat is disabled. Some people might have to put it in the Q&A.
Yeah, so, sorry about that.
No, don't worry. So if people want to write their answers in the Q&A instead, then maybe we can think through together the impact of the asylum ban on sections 2 to 9 in particular for Rafi. Laura has said Rafi won't be removed. He won't be able to be removed because Afghanistan is not a safe country, so he'll be stuck in the UK with no access to asylum support. So he'll be destitute. Shazia says the claim will be admissible and therefore living in limbo because he cannot be removed to Afghanistan. Okay, really helpful thoughts. Thank you. And Mohammed has said he can apply for Section 4 asylum support. Here are some of the things that I think will happen to Rafi or are likely to happen. Anonymous has also said he's come from a safe country, so will be removable to a safe third country. Okay, Rafi likely meets the 4 conditions in Section 2, right? Because he arrived by a small boat and he's arriving on the 1st of January 2024, which is after the 20th of July 2023. Because he arrived on a small boat, we know he probably came in via France and Belgium, and I would assume that the Home Office in almost every case will say these were safe countries through which people passed or stopped through, even if it was just to get onto a small boat there. It's important, nevertheless, to take instructions about it, about whether someone's life and liberty were threatened in every country through which they passed for a refugee convention reason. If they haven't passed through a safe country, then they may not meet that condition in Section 2. So really important to take instructions. As I said, if you memorize anything from this, memorize the 4 conditions in Section 2. Slightly different things might apply. As I said at the beginning when we were talking about Rafi, is Rafi an unaccompanied child? We don't know. There's no instructions. Instructions will need to be taken on it. If he is an unaccompanied child, as in he meets the 4 conditions in Section 2, he's under the age of 18, and at the time of his entry or arrival, no individual, whether or not a parent who was over the age of 18, had care of him, then the duty to make arrangements for his removal might not be a duty, it might be discretionary, it might be a power for the Home Secretary to make those arrangements. If I were advising Rafi, I would tell him to make clear that he wishes to make a protection and human rights claim regarding his return to Afghanistan. Now, we know that when asked in the screening interview, he said that he was afraid of the Taliban, and that's good, but we want to make sure, and again, I don't know the process for this, that the fact he wants to make an asylum and protection claim is recorded and that it's considered that he has tried to make it, but it's been declared to be inadmissible. And I don't yet, as I say, know the process for how that's done. If Rafi doesn't make an asylum protection or human rights claim, and he is an unaccompanied child, then that's one of the reasons why the power to remove someone from the UK who is an unaccompanied child can be exercised. Otherwise, if he's a child, that power becomes a duty, as we said, on his 18th birthday. If Rafi is not an unaccompanied child, the Home Secretary has a duty to make arrangements for his removal as soon as reasonably practicable. Section 2 read with Section 5 of the Act. Any protection or human rights claim regarding his removal to Afghanistan, the Home Secretary must declare inadmissible. This inadmissibility regime applies whether he's a child, an unaccompanied child, an accompanied child, or an adult. It applies to everyone across the board. There's no exception for unaccompanied children as we find in guidance now. So if Rafi meets the 4 conditions in Section 2, that's it. The Home Secretary must declare his protection or human rights claim inadmissible. But Rafi cannot be returned to Afghanistan, as some people have identified. because Afghanistan is not one of the countries from which people can be returned to if their human rights or protection claim is not considered. Those are only the European Economic Area countries, Switzerland and Albania. Albania being the obvious one, which is likely to cause a great many issues for people in practice and for the individuals themselves. So what does Rafi need? And this is where people need to be signposting if they're not legal practitioners themselves. Rafi obviously needs really urgent legal help, assistance, advice regarding his removal notice to Rwanda. He's already tried to seek advice through the Detained Duty Advice Scheme, but he still doesn't have a legal representative who's helping him respond to the removal notice. So that is the most urgent thing on his agenda. The second thing, as Mohammed identified in the Q&A, is that Rafi must also can also make an application for Section 4 support, given that his claim is inadmissible. Again, we don't yet know the practicalities regarding when a claim is recorded, when a claim is inadmissible, but we know that the Home Secretary has said that any claim that he makes would be inadmissible. Does that make sense to everyone? I hope it does. I'm just going to check if there's any questions. Juliet has asked, does that mean that all claims from France will be deemed inadmissible? If you mean all claims from French nationals, then yes. If someone meets the conditions of Section 2, regardless of what their country of nationality is, their claims must be declared to be permanently inadmissible. If you mean for someone who passed through France, then in those circumstances, I think the Home Office is likely to interpret the Section 2 condition regarding passing or stopping in a safe country as meaning France is included in that. So the vast majority of small boats, which we know was their intention at the outset with the Illegal Migration Act, are likely to be caught by that condition of Section 2. Just checking. Francis has asked if how does the Section 4 support apply? And this is exactly what I was saying, Francis. We don't yet know the process for it. We do know that the intention in amending the 1999 Act was to make it so that inadmissible claims under the Illegal Migration Act are eligible for Section 4 support. I know that some brilliant minds in the sector, like ASAP, are thinking about asylum support and definitely taking it forward. And so if this does become an issue, we can certainly consider providing some specific ILPA training on Section 4 support under the IMA. But at this point in time, I don't think that there's enough information about how it's going to apply in practice. Anonymous attendee has said, if Rafi was claiming to be a child at the screening interview, I assume, is there not a requirement for an appropriate adult to be with him? Is there an obligation for a border force to interview him at a later date? Again, anonymous attendee, we don't yet know how the Home Office intends to implement this specifically for the Illegal Migration Act. There's no guidance yet, and I certainly haven't had a discussion with the Home Office in relation to accompanied or unaccompanied children. It's also quite unclear still how age-disputed children will be treated under the Act and whether they will simply fall into the adult process if their demeanor looks to be significantly over the age of 18 in appearance, or whether they're going to come under the sort of unaccompanied child, or whether there is going to be some middle regime. It's not detailed in the Act, and that's really what I want to focus on today. If and when more guidance becomes available, then we will definitely try to advise. Juliet, no, I don't know what. Yes, we know that those deemed inadmissible can make Section 4 support applications, and that's detailed in Section 9 of the Act. You can take a look at what it does. All it does is amend the 1999 Act to include IMA inadmissibility. Anonymous attendee has asked, do we anticipate that further countries are likely to be added to the schedule soon? Is Afghanistan likely to be added? I hope not. I would think that Afghanistan is not a country that the UK is intending to send individuals back to at the moment, but it's really difficult to know. June has asked, if Rafi says he's a child, will he be obliged to have an X-ray now? And again, it comes down to the scientific methods of age assessment, and that's not even covered. The new provisions aren't even related to the Illegal Migration Act per se. They're the ones under the Nationality and Borders Act. And then, of course, there's the new 2 sets of regulations coming into effect in relation to age assessment. I think that it's highly likely the Home Secretary in these circumstances, if Rafi's not very clearly a child, may wish to ask Rafi to undergo scientific intrusive methods of age assessment, multiple methods in order to determine Rafi's age and the likelihood of his age. However, there is still the ability to refuse consent. The thing to be cautious about is that it can damage credibility under the Nationality and Borders Act. The Illegal Migration Act contains some slightly different and confusing things on age assessment, which we'll touch on briefly. But yes, June, it's possible that he will be asked to oblige to. I mean, I think we'll have a dispute with the Home Secretary about whether saying negative credibility inferences constitute essentially forcing someone's hand, because they're so concerned about the adverse consequences of refusing. Rowan has asked, is there any consideration about the impact of a person in limbo and the public expense with this act being a practical failure? There has been quite a bit of consideration on it throughout the passage of the Act, including by the Labour government, the Labour Party, Labour Party in their opposition to the Act. But in terms of actual financial numbers about impact, the impact assessment to the Illegal Migration Bill was only published at a very late stage. And I don't think it's comprehensive insofar as it's looking at the impact on third and charity sector. As far as I'm concerned in relation to the legal aid side of things, I don't think this has been adequately considered throughout the passage of the bill or even now in its implementation stage. Julia has talked about the status of permanent limbo engaging Article 8, and I completely agree. But as I'm sure Julia will know, it will really come down to the jurisprudence surrounding Article 8, and it's quite difficult when it comes to limbo. All right, I think that's enough questions on asylum, Ben. What do you think, Clara?
Yeah, that sounds good. I just wanted to point out that I've enabled the chat again, so people can post messages and questions on there as well if they wish.
Thanks. I know some people have asked if we'll send out the slides, and we'll definitely send them out after the training. I think we should just move on to detention now. So the next bit of the Act relates to detention and electronic devices. Now, electronic devices were shoved in there relatively late during the passage of the bill, and so they don't really suit the rest of the provisions which are about detention and bail. They are the etc. at the beginning of those sections, but just be wary that they are there. And as I mentioned, they have been commenced for the purposes of making regulations. Also, credibility has been commenced in section 62. If we move on to look at the detention powers, quite briefly, because we will have separate seminars that are covering these in more depth, we see that section 11 introduces wide new powers for detaining persons that the Home Secretary considers. She may have a duty to remove or has a duty to remove. There are new powers for detaining unaccompanied children, and what section 11 does is it removes statutory time limits, which also presently exist in the 2014 and 2016 Act, which limit the length of detention of pregnant women, of unaccompanied children, and of accompanied children, including where they can be detained. Instead, section 11 says that people can be detained in any place that the Secretary of State considers appropriate. And so there's quite large and fundamental changes to the powers of detention for people who come within the Section 2 duty. Then what we see in section 12, as we've talked through in some depth already, is that the length of detention is affected in section 12, and section 12 seeks to overturn the well-established common law principle about the court deciding the length of whether the length of the detention is reasonable. and it affects the grace period. Section 13 then is quite crucial, and this is where it comes in for most people who are thinking about how to challenge detention. If someone like Rafi presents themselves to you and they are in detention, what are their options for getting out of detention? And Section 13 tells us what the options are under the Illegal Migration Act. And in one word, they're extremely limited. So what Section 13 does is it aims to make it very difficult for people to challenge their first 28 days of detention. There is a slight concession that was introduced in the last few days before the bill was passed through Parliament, which was to create a small carve-out for unaccompanied children who are detained for the purposes of removal or pending a decision to remove them. But other than that, everyone else is prohibited from having the first tier tribunal grant them bail for the first 28 days of their detention. For the unaccompanied children cohort, it's 8 days. But there's no guarantee that the first tier tribunal will in fact grant bail in those cases. And so the question then becomes, what other ways do I have to challenge that? Nothing in the Act says that the Home Secretary cannot grant bail, so you can always ask the Home Secretary to grant bail. Judicial review, however, is restricted, particularly for the first 28 days of detention. There's only 2 grounds on which a judicial review can be brought challenging detention, and that's bad faith or procedural defect, which amounts to a fundamental breach of the principles of natural justice. And so that leaves, after those 28 days, then you have the general public law grounds. My reading of Section 13 is that it's just the first 28 days where judicial review grounds are limited. Section 13 then leaves only for the first 28 days as the remedy to challenge detention an application for writ of habeas corpus. All right, and then we have Section 14, which disapplies the Home Secretary's duty to consult independent family returns panel, and Section 15, which gives the power to search persons liable to be detained for their electronic devices. If we can just move to detention questions. I think that would be a good idea. And I think there was still one in the Q&A from before.
Yes, a question from Mauricio. Do you want me to read it out, or do you have it?
No, I can read it. So Mauricio says, practically for Section 12, the practice of submitting an application for leave and then subsequently a bail application for someone in detention is no longer possible. How does Section 12 affect bail applications? So Section 12 doesn't affect bail applications. Section 13 does affect bail applications for people impacted by the Illegal Migration Act. So if we look to Rafi's situation again, what are some issues for Rafi? So if Rafi is an unaccompanied child, then he can only be detained in the circumstances specified in regulations, and these regulations have yet to be laid, so I can't tell you what they are. Section 11 also says that unaccompanied children, the regulations may contain a time limit, but they may also not contain a time limit. So we'll have to see what the government does in relation to detention of unaccompanied children. I think the important thing to take away is that there's no statutory time limit anymore for detention of unaccompanied children, whilst there currently is, which is 24 hours. So if a child meets the Section 2 conditions, then they can be detained indefinitely up until any regulations may have the time limit, and subject, of course, to Section 12 and Article 5 of the European Convention on Human Rights, Hardiel saying all of these things which may still be argued. Anonymous attendee has said, would Article 5 become more relevant in challenging detention pursuant to the changes introduced by the IMA? I would say yes, but as I said at the very outset in relation to human rights and compatibility with human rights, in this Act, Section 1(5) of the Illegal Migration Act disapplies Section 3 of the Human Rights Act. So if you're hoping that a judge will be able to read down sections 11 to 13 in light of Article 5 of the European Convention on Human Rights, you may find that their hands are tied by the disapplication. And so Section 4, declarations of incompatibility, become all the more relevant. But Strasbourg may well be helpful and may be the forum for resolution of these questions of compatibility with convention rights, including with Article 5. But as I was saying at the beginning, Article 12 is a really good, Section 12 is a really good example of where it may be in conflict with Article 5(1)(f), and there's likely to be further litigation. There already has been some litigation, but there's likely to be further litigation on that grace period aspect of Section 12. Okay, so back to Rafi. So if Rafi is an unaccompanied child, he can only be detained, as I was saying, in the circumstances that are specified in regulations. We don't yet know what these are. If he's an accompanied child, there's no statutory time limit. There's no regulations that are going to say which circumstances where he can be detained. There's no time limit which may be introduced in regulations. So it would appear there is an indefinite period for which an unaccompanied child could be detained, subject to other challenges. He can also, Rafi, be detained in any place the Home Secretary considers appropriate, and that's if Section 11 comes into effect. This could mean that we're talking about a place other than an immigration removal center. And it's concerning, of course, given the relatively small current size of the detention estate. But we also see that the Home Office has intentions to increase that detention estate. But there's also increased use at the moment of contingency accommodations such as MOD sites. Accommodation centers are always being discussed. Barges, as we all know, are very much a reality now of the migration landscape. And so I would be concerned about this in any place aspect of where a person can be detained, particularly as we know at present, it is only the immigration removal centers where there is this duty advice rota scheme, the detained duty advice scheme, in which a person can access legal advice. So we don't know if they detain people in other places, what mechanisms they're going to put in place to ensure that people have access to legal advice. In terms of challenging detention, if we look to Section 13, we can see that Rafi has really limited means to challenge detention. He needs some urgent legal advice on his options to do so. I would say the first thing to do would be to gather all the evidence and put forward the application to the Home Secretary, because she's not prohibited from granting bail. Only the first-tier tribunal is. In most cases for 28 days, as we said, unless Rafi's an unaccompanied child who has a decision pending his removal or pending his actual removal, which in these circumstances, it doesn't appear that he does. And judicial review grounds are also quite limited for Rafi in the first 28 days. So bad faith and procedural defect that amounts to a fundamental breach of the principles of natural justice. I don't know what others think, but those are extremely narrow grounds, in my opinion, and it's unlikely in the vast majority of cases that people will be able to prove that those two grounds are met. So that leaves habeas corpus, which is about whether the Home Secretary has lawful authority or power to detain a person. And as we can see from Section 11 introduces these wide new powers. And so there is a real question, a real debate still, one that will need to be resolved by the courts about the scope of habeas corpus as an effective remedy to result in the release of a person such as Rafi in the first 28 days of their detention, particularly in light of the limited grounds for judicial review. Habeas corpus claims are not made regularly, so there's going to be a small number of lawyers, particularly public lawyers, who are experienced in these matters. And for that reason, Clara and I are hoping to arrange another specific seminar with such experts that explore these complex legal issues and also explain the process for making applications for a writ of habeas corpus. I think someone might have their hand up, Clara, or was I imagining that?
Yes, no, let me allow them to talk. They should be able to talk now. Dominic, if you unmute yourself, you should be able to talk. I can also try and unmute if you have issues. No?
I'm sorry. I just wondered if the slides were stuck, but should we be at number 3, accommodating unaccompanied children? Is that
No, we definitely shouldn't be yet, but it's what's up next if there were no questions. I just thought maybe we were moving on.
So we should be at detention questions?
Yes.
Okay, that's what I see now. Thank you. Sorry.
Okay, great. Thank you, Dominic. Agnes has said the protection of detention of unaccompanied children under 18B and pregnant women under Section 60 of the 2016 Act will still apply to other detentions, but not those subject to the duty to remove under Section 2. Yes, Agnes, that's right. So the protections that currently exist for accompanied children also, and unaccompanied children and pregnant women will apply to people who are not subject to the duty to remove and who are not detained under the new powers created by Section 11 of the Illegal Migration Act. But Section 11 of the Illegal Migration Act removes these for those new powers. It creates a new time limit for detention of pregnant women, which it introduces 72 hours or 7 days with ministerial approval. So it's the pregnant women detention concession was one of the only concessions that was made throughout the passage of the Illegal Migration Bill. For unaccompanied and accompanied children, there was no concession from the government in terms of an actual statutory time limit. I hope that answers the question. Okay. So now, Dominic and everyone, we're moving on to accommodating unaccompanied children. And this is one that I said in the overview of the session that primarily we would be looking to signpost rather than to go through this in great detail. But I think it might be helpful to just very briefly go through section 16 to 21. So starting from the top, Section 16 permits the Secretary of State to provide or arrange the provision of accommodation for unaccompanied children in England, including allowing the Secretary of State to ask a third party to provide that accommodation. It's quite clearly intended to embed in the Illegal Migration Act and put on the statutory footing the unlawful Home Office practice of accommodating children in hotels for extended periods of time. And as we said throughout the passage of the bill, we know that large numbers of children, hundreds of children have gone missing from those hotels, and it's generally assumed that they have been taken by traffickers. What Section 16 does is, as I say, to place that in primary legislation. So there's no time limit on how long a child spends in Home Office accommodation in Section 16. It undermines the legal duties in the Children Act 1989. There's no standards, there's no safeguards or protective obligations for the Home Office, which is providing the accommodation for children at the moment. The Children Act 1989 contains such a safeguard. In Section 20, the accommodation must be suitable, and also accommodation provided to children age 15 and younger must be regulated. Section 16 of the Legal Migration Act doesn't contain that. Also, it contains no information on what other support is required for the Home Office accommodated children. There's also no explanation as to how children who are accommodated by the Home Office will access their entitlements from the local authority, particularly with regard to education, health protection, and care planning. Then Section 17 goes further, and it creates a power for the Home Secretary to decide that a looked after child is to cease to be looked after by a local authority in England, and it must direct the local authority to cease looking after the child on the transfer date. This is quite problematic, of course, because even recently it's been decided by the Divisional Court in February that the looked after decision is simply outside the Home Secretary's competence and knowledge base. Nevertheless, this is what Section 17 intends to do. Section 18 and 19, we anticipate will undermine the child protection functions of local authorities because they allow the Home Office to seek information from local authorities. So Section 18.2 gives the Home Secretary the power to direct a local authority to provide information about the support or accommodation provided to children who are looked after by the local authority, and this is the important bit, such other information as may be specified in regulations made by the Secretary of State. That is incredibly wide, and it could undermine the important confidence and trust that is built between a child and the local authority if the local authority is then obliged to share this information with the Home Office. And they are obliged because Section 19 then provides for an enforcement mechanism to ensure that local authorities comply with the information requests. Section 20 creates a broad delegated power for the Home Secretary to amend any enactment, and it overreaches into devolved powers. Section 21 then puts the National Transfer Scheme on a statutory basis for IMA children. But it's quite important to recognize, that in relation to Section 16, and just going back to the question that Una mentioned, what it does is it applies to unaccompanied children arriving on or after the 7th of March 2023, and I'm sure that ECPAT has much to say about how this interacts with their successful case regarding unaccompanied children who have been accommodated by the Home Office, because this is retrospective. Okay, moving on to modern slavery, we see that sections 22 to 29 of the Act apply to modern slavery. It is our view that the modern slavery and trafficking provisions in the Illegal Migration Act breach the UK's obligations under Article 4 of the European Convention on Human Rights, but also Article 4 of the European Convention on Action Against Trafficking. So under Article 4 of the European Convention on Human Rights, I'm sure that people know that states are obliged to set up a spectrum of safeguards that must be adequate to ensure the practical and effective protection of the rights of victims or potential victims of trafficking. So there's this positive obligation on the states to protect the victim of trafficking from further harm and to facilitate their recovery. What the Illegal Migration Act does is remove almost all protections for victims of modern slavery and trafficking who are targeted for removal, and it then exposes them to a substantial risk of re-exploitation. In particular, the victims aren't going to be given time and a place of safety to recover from their experiences, and they may in fact remain in situations of exploitation without any incentive to come forward, given that once they do come forward, they're likely to face the removal process under the Illegal Migration Act if they meet the 4 conditions in Section 2. For a person who is targeted for removal under Section 2 of the Act, who the Home Office decides is a potential victim of trafficking, Section 22 of the Illegal Migration Act makes it so that there's no obligation to grant such potential victims leave to remain, and they can be removed from the UK before a conclusive grounds decision is made. There's then just a really narrow exception, and it's incredibly narrow, and it was further narrowed during the passage of the bill for some individuals who are cooperating with investigations or criminal proceedings relating to their exploitation. If the Home Secretary considers it's necessary for the person to be present in the UK to provide that cooperation. Now, that's likely to benefit a very small number of individuals, especially as the Home Office's own statutory guidance recognizes that often people don't feel safe enough to come forward until they have time to recover. The section also was amended to say that the Home Secretary must assume that it's not necessary for a person to be present in the UK unless the Secretary of State considers there are compelling circumstances which require the person to be present in the UK for that purpose. And compelling circumstances are to be set out in guidance. They're not defined in the Illegal Migration Act. That's an overview of the modern slavery provisions. And then I just wanted to move on to entry, settlement, and citizenship. And then we'll have a some time for questions at the end of that section. I think maybe, Clara, it would be good to have just a short break now, maybe 10 minutes, and people can come back in 10 minutes and we'll move on to entry, settlement and citizenship. Does that sound fine?
That sounds good. Yeah, I'll pause the recording and then we'll see everyone at 11:45. Right.
Yes.
Thank you, Chloe.
Get the recording. Great. Thank you, everyone. I hope everyone enjoyed a good little 10-minute comfort break. So let's crack on with entry, settlement, and citizenship. And the reason I wanted to move on without taking any questions from the previous sections is entry, settlement, and citizenship is quite crucial. And also we still have the entire suspensive claim and appeal process to go. And my goodness, it's complex. So let's move on to entry, settlement, and citizenship. It's contained in sections 30 to 37 of the Act. And if we take it section by section, you can see that section 30 is a very crucial section. So what it does is it bars people who are targeted for removal, but who have arrived on or after the 7th of March. So it's the retrospective provision from limited leave to remain, limited leave to enter, entry clearance, ever being granted an electronic travel authorization, and indefinite leave to remain, all subject to very limited exceptions. Section 31 then sets out who will be ineligible to acquire British nationality and extends the ineligibility to people arriving and entering the UK, and also the Channel Islands, the Isle of Man, and British Overseas Territories. Section 32 is then also quite crucial for most refugees because it provides that ineligible persons will not be able to register or naturalize as a British citizen under the specified provisions in that section. And if we move on to sections 33 to 35, we'll see that these relate to the other forms of British nationalities: British Overseas Territories citizenship, British Overseas citizenship in section 34, British subjects in section 35. And then we have in section 36, the exception for all of these citizenship provisions. And that's where we'll talk about it in a second, but it's in relation to compliance with the European Convention on Human Rights, so extremely narrow. Section 37 then just makes the consequential amendments to the British Nationality Act 1981. So section 30 is important, as I say, for all forms of leave, ETAs, entry clearance, and 31 to 36 for all forms of British nationality. If we want to take a closer look at the provisions, I think it's really important to look at the exceptions. Because as I say, on the whole, people arriving on or after the 7th of March 2023 who meet the other 3 conditions in section 2 are unable to secure lawful re-entry, residence, and citizenship in most circumstances. But what are the exceptions to these? So I've copied here the provisions from section 30 itself to begin with. If we look at the entry, leave, and settlement ban, it says under section 8A, which section 30 of the Illegal Migration Act inserts into the 1971 Act, that a person must not be given leave to enter or leave to remain in the UK unless it is, and there's 2 exceptions here. One is for unaccompanied children, and one is in relation to victims for slavery or human trafficking. And a person must not be granted an entry clearance or an ETA. Now, if we take a look at the exceptions, one need only scroll slightly further down in the same section, section 30 of the Act. We see that section 8AA3 of the 71 Act says that the Secretary of State may, so not must, but there's a discretion, give the person limited leave to enter the UK or grant the person an entry clearance or an ETA if the person has left or been removed. So we're talking about a very small cohort of individuals who have left or been removed under the Illegal Migration Act, who would meet the 4 conditions of section 2, except they arrived on or after the 7th of March. In those circumstances, they can be granted limited leave to enter, an entry clearance, or an ETA if the Home Secretary considers that, under B, either granting would breach the UK's obligations under the Human Rights Convention, or there are other exceptional circumstances, which is very wide, and exceptional circumstances is not defined in the Act. So again, this applies to where someone has left or been removed who would otherwise meet the conditions, and they want to come back, they want to re-enter the UK. Then the ban is in place unless it would breach the European Convention on Human Rights, or there are other exceptional circumstances. And then if we scroll down slightly further to section 8AA4 of the 1971 Act, which, as I say, this is all now in force and has been in force since the 20th of July 2023. Well, the Secretary of State may give the person limited leave to remain. And so this is the exception for limited leave to remain. It's a very crucial one, as a vast majority of individuals arriving who are seeking asylum, this is what they want. They haven't left and they're not seeking re-entry at this point in time. If they want limited leave to remain, they have two exceptions in section 8AA4. A is where it would contravene the UK's obligations under the Human Rights Convention or any other international agreement, and I'll get on to why this is important in a second, to which the UK is a party. Or B, where the Home Secretary has exercised the power in subsection 3. So that's the power we just talked about. If we go back in subsection 3, to grant them limited leave to enter an entry clearance or an ETA. So if she has exercised that power, and there are still other exceptional circumstances which apply and make it appropriate to give the person limited leave to remain. This is the exception in section 8AA4 for limited leave to remain. And then if we keep moving on to the next provision, and I saw that there was a hand go up, but we'll do questions at the end. So if we move on to the next provision, section 30 of the Illegal Migration Act also has a subsection 4. And subsection 4 introduces a slightly strange exception. And I would say it's not really clear how it's intended to apply. So what it says is that up until section 2.1 comes into force in relation to a person, section 8AA, which is what we just read through, the ban with the limited exceptions, has effect in relation to that person, as if it also permitted the Secretary of State to give the person limited leave to enter or remain in the UK in any other circumstances. So very wide discretion to grant limited leave to enter or remain in any other circumstances until section 2.1 comes into force in relation to a person. So if we're talking about a person who entered or arrived in the UK on or after the 20th of July 2023 and meets the 4 conditions of section 2.1, well, up until section 2.1 comes into force in relation to that person, which it's not yet in force, there's this wide discretion to grant them limited leave to enter or remain in the UK. Now, limited leave to enter is then further narrowed slightly in sections 35 and 36. If a person leaves and then re-enters, then they're only permitted to come back and do so in certain circumstances. Importantly, section 37, however, says that any leave to enter or remain in the UK given to a person under section 34 of the Illegal Migration Act is to be disregarded in determining, for the purposes of this act or any other enactment, whether the person meets the 4 conditions in section 2. So if you were hoping that using this wide discretion in section 34 would result in a client or a person you're assisting being able to escape the section 2 conditions, it doesn't. The Home Office has already thought about that and they've put that provision in. Let's just move on briefly to citizenship then. What do the citizenship provisions do? So as I say, people are barred from most forms of British nationality. When the bill was introduced, believe it or not, it actually created it had even worse provisions in relation to citizenship, and what it would do would apply it to anyone who ever met the conditions of section 2. Well, any of their descendants would also be captured by the citizenship ban, but thankfully the Home Office itself removed that during the passage of the bill so that children aren't penalised, particularly if they're not yet born, for the actions of their parents. However, it still contains really important provisions that bar citizenship and that it's important to be advising your clients on. So again, Section 32(1) removes the entitlement to register as a British citizen, and that's including for minors who are born to British citizens by descent under Sections 3(2) or 3(5) of the British Nationality Act. And it also removes the ability of the Home Office to exercise her discretion under that catch-all discretionary provision in Section 3(1) of the British Nationality Act to register minors. Additionally, as we mentioned, the provision in relation to naturalizing adults under Section 6 of the 1981 Act is also banned, and it removes the option of requiring overseas territory citizenship, and British subject status. But what's the exception for citizenship, and what's the exception for indefinite leave to remain? Well, it's quite helpful because they're the same, and so that's why I put them on the same slide. In both, they can be granted indefinite leave to remain or disapplied from these citizenship provisions if it would contravene the UK's obligations under the European Convention on Human Rights, if they were not so granted. And so that is a very slim exception clause, which doesn't really save the very wide ban on indefinite leave to remain and citizenship. I just wanted to look really briefly at UNHCR's recommendations, which were published on the 6th of October 2023, and I think are really excellent in this regard, and I would encourage everyone to take a look at them as well. They're available online publicly. So what UNHCR says in their recommendations is that they encourage the Home Secretary to adopt immigration rules and also publish policies confirming that the Home Secretary will exercise her new discretionary powers in the Illegal Migration Act by granting refugees and stateless people a form of leave to remain that complies with the UK's obligations, both under the Refugee Convention and the 1954 Statelessness Convention. And it's important to note also paragraph 9 here, and the point is that people who have been arriving on or after the 7th of March 2023, in particular until 20th of July 2023, are not subject to the Legal Migration Act's provisions, including the asylum ban. And even if they have arrived after the 20th of July 2023, because those provisions are not yet in force, there's also no asylum ban that is yet in force. So all that we have is the current inadmissibility procedure, which is contained in the Nationality and Borders Act 2022, which introduces Section 80B. And so this means that people are still making asylum claims, and they're still subject to the same procedures that they have been for the past more than a year now. And in those circumstances, if they are recognized as refugees, they should be granted limited leave to remain, particularly before Section 2(1) comes into force. And that's what Section 34 is there to argue. But Section 8AA4, as I'm sure people recall from when we just looked at it, relates to where a person can be granted limited leave to remain if it would breach our obligations under the ECHR or any other international agreement to which the UK is a party. And so it's quite helpful that UNHCR's recommendations also give a really helpful breakdown of the rights that should be attached to limited leave to remain. And in relation to indefinite leave to remain, moving on, UNHCR has recommended in relation to long-term precarity that it can engage Article 8, as one of the helpful attendees put in the chat. Again, what will need to be addressed is the Article 8 limbo case law, and when it becomes the case that someone has to be granted indefinite leave to remain due to the precarity of their status. All right, entry, settlement, and citizenship questions. So if we turn our mind back to Rafi, and I know everyone is probably getting quite sick of poor Rafi, but if we turn our mind back to him, on what bases do you think that Rafi can be granted limited leave to remain? And Clara has said that the chat is now up and running, and I've seen messages there. So if people want to put their thoughts in the chat, then that would be really wonderful. And just whilst people are doing that, I see there's one question in the chat that Mohammed has asked, which is, does it mean that someone who has been granted some sort of leave will never be able to apply for British citizenship? And the never is subject to the exception, which is contained in section 36 of the Illegal Migration Act, which is where it would breach the European Convention on Human Rights.
Thanks, Zoe. There's also a question in the chat from Francis saying, will this mean that people here for 20 years plus will no longer be able to make a long residency application?
Well, Francis, my view is that people can make applications under Section 8AA4 on the basis that it breaches their rights under the European Convention on Human Rights or breaches any other international agreement in addition to the Section 34. So if we assume, as with Rafi's case, that Section 2.1 is now in force, then they would still have that Section 8AA4 ability to make an application, but they would have to plead that not granting them limited leave to remain after 20 years, including periods of without any status, would breach their rights, for example, under Article 8 of the European Convention on Human Rights.
Thank you, Zoe. There's also 2 raised hands from Agnes and Emily. Did you want to take these questions, or did you want to see in the chat? Some people might have answered the case study questions. Not sure which one you want to address first.
I think let's take the ones, the people with their hands raised first, and then I'll take a look at all the questions in the chat.
All right. Emily, I don't know if you still have a question. I can see that you had your hand raised before, so let us know if you still want to ask your question.
Emily says she's worked out the answer, but maybe it was a helpful question, Emily. Maybe you should tell us what your question and answer was. Don't be shy.
Then Zoe, I'll have to admit that I accidentally pressed it.
Sorry.
But it has been brilliant so far. Thank you.
Wonderful.
Thanks, Clara.
But all right, thank you.
Agnes, is that a real hand or an accidental hand in that case?
It hasn't been lowered so far, so I'll allow Agnes to come in.
Oh, I think it was a mistake. I beg your pardon. I didn't realize I'd raised the hand. I'm so sorry.
That's fine. Don't apologize. It's fine. There's a lot of buttons on Zoom. Okay, let's take a look at the chat then. So Carol, regarding the accommodation with the Home Office, what Section 16 does is it creates the ability for the Home Office to accommodate children, and so it's in direct conflict with the Children's Act 1989. We'll have to see how this plays out, but it's not yet come into force. I should have emphasized that. Although it's retrospective and applies back to the 7th of March 2023, it is not yet in force. Mauricio has asked questions in relation to this section that we're looking at, entry, settlement, and citizenship provisions, and said, is it only possible under the Home Office discretion if it contravenes the international agreements and convention rights? I'm confused, so this opens the door for discretionary applications to be made anyway. Yes, essentially, I agree entirely with your analysis, and I think it does open the door. Nisa has asked if an application for leave to remain is made on the basis of an exception under Article 8. Does this suggest we are going back to making Article 8 arguments? Yes, I would think so, Nisa. Dominic has said, can you clarify the interplay between Section 8AA1, which is mandatory, and Section 8AA4, which is discretionary? How can the two coexist? Good question, Dominic. So let me figure out how to work the screen. And also, I don't think I've put the entirety of section 8AA on there, so I'm just going to open it up. So the part of section 8A, it is here. So section 8AA2 says subject to subsections 3 to 5. And so I hope that that answers the question. So from the outset, the mandatory obligation is subject to subsections 3 to 5, which contains the discretion to grant. But let me know if that doesn't make sense. Francis has asked, does the implication of the Illegal Migration Act on discretionary registration for British children mean that local authorities should really be making these, if possible, before this comes into force for children who may have entered illegally? The problem, Francis, is that this section and all of these sections we've been talking about, sections 30 to 37, are already in force. So if a child is subject to the section 2 conditions, meets all of those, plus they arrived on or after the 7th of March rather than the date that the Act passed, then they already are subject to the citizenship ban, including the discretionary citizenship ban in section 3.1, if that's the discretionary kind of application that you were considering. Sheila has asked, do you think that particular categories of persons, such as those who with experience of trauma or torture, are more likely to be successful applications under section 8AA4, and particularly 8AA4B, or section 34? I mean, I suppose the problem with section 34 is if it is more time limited up until section 2.1 comes into force. And so, as we were saying at the outset, really difficult to know when it will come into force, particularly in relation to a person, what's meant by that. But in relation to section 8AA4, I think that the exceptional circumstances provision is, again, unlikely to apply to most people unless they were somehow granted leave to enter, entry clearance, and ETA under 8AA3, which I think is not the vast majority of people that we're talking about. But in relation to contravening the UK's obligations under the Human Rights Convention or any other international agreement, there may be some argument, but I do think that very strong arguments lie in relation to breach of the Refugee Convention and the Statelessness Convention, the 1954 Convention. And that's not particularly impacted by whether someone has experienced trauma or torture, but I have to admit I haven't applied my mind to that specific question before. Mohammed has asked in relation to the case study, based on the UNHCR recommendation to use the discretionary power to grant leave to remain to Rafi to meet the requirements of international law and provide protection to Rafi as he cannot be removed to Afghanistan. And someone else has said, okay, has made a different comment in the chat. Yeah, let's just run through the Rafi scenario and then I'll come to the anonymous attendee in the Q&A chat. So on what basis can Rafi apply for limited leave to remain, being the question. If Rafi is a child, then also remember that there is that specific discretionary leave provision, which is contained in section 8AA. Also, whether Rafi is an adult or a child, exactly as Mohammed said, and as Dominic has said, this opens the door to the discretionary leave to remain application. I would encourage people to consider discretionary leave to remain applications and make them where suitable for anyone who has arrived on or after the 7th of March 2023 to whom this ban applies, on the basis that failure to do so would either breach the European Convention on Human Rights or any other international agreement. And until Section 2.1 comes into force, for those people, they can also make a discretionary leave to remain application on that basis. But for Rafi's scenario, because we are presuming that Section 2.1 has come into force, he cannot apply on the basis of Section 34. So that wide discretion in any other circumstances, the Home Secretary is permitted to also grant limited leave to enter or remain. That one is not available to Rafi. Okay, moving on to, oh, Carol has her hand up, and then there was one anonymous attendee that I forgot about in the chat. So the anonymous attendee says, does this act not disincentivize EU states across from the Channel from entering into a returns agreement with the UK? If they were to do so, virtually any migrant arriving from France or Belgium would be removable back across the Channel within a very short period. Anonymous attendee, I agree. I think it is likely to be the case that if the UK can agree a returns agreement or be part of any European system, they will need to give something in order to get something. And so if the idea is to remove everyone back through a country in which they pass, or a country willing to accept them, then I think European countries will be very concerned that they might have to accept a large number of people. And so the real question becomes what the UK is willing to give in return, how many it's willing to accept from the front lines, or how much money it's willing to give. As we all know, those discussions are ongoing in Europe at the moment. So I think it will very much depend on that. Carol, sorry to keep you waiting. Do you want to come in?
I think I messaged Carol to ask if it was a purposeful raised hand, and I haven't heard back. So I think I will.
Okay. I'll just click the little X next to Carol's name. Perfect. So that takes us on to legal proceedings, with not too much time left in the seminar, because you've all been hearing me chat at you for a very long time now. I'm sorry for that. This is by far, I would say, the most complex part of the Act for me to wrap my head around, maybe because I'm thinking about all of us having to deal with it who are legal practitioners. In essence, it creates a new fast-track scheme. As you can see, it's also one of the largest parts of the Act that we're looking at today. It's sections 38 to 56. So it's much more meaty than some of the other provisions, including, asylum ban and detention, which were only a couple of sections of the Act. What it does is create this new suspensive claim process and also a new suspensive appeal process. It also contains many other things about the procedure and judges, as we said, first-tier tribunal judges and now upper tribunal judges, and also a provision in relation to legal aid. And so I'll try to cover this in some of the limited time that we have left, but it is incredibly complex, and I've struggled to wrap my own head around it, to be frank, in the last 9 months or so. So section 38, if we just go section by section, and then I'll explain what it means. So section 38, it's an interpretation section for the legal proceedings part. Sections 39 is 39 to 53, sorry. Importantly, it defines what a third country removal notice is, and it's a removal notice which a person is to be removed to a third country. So what it says on the tin, but this becomes quite relevant when we're talking about the suspensive claim process, because at times there's references to removal notices and other times references to third country removal notices. In Rafi's case, he's received a third country removal notice, because the Home Office is not proposing to remove him back to Afghanistan, but rather to remove him to Rwanda. So then we have section 39, and it defines what a serious suspensive harm claim is, and what a serious harm condition is. Section 40 then allows the Home Secretary later on to go back and tweak the definition in section 39, but it doesn't permit removal of the examples there. She can add to them, and she can make further provision about what a serious harm suspensive claim means and the serious harm condition means. Section 41 provides that a serious harm suspensive claim is not a human rights claim and does not attract a right of appeal, but a person can make a human rights claim regarding their removal to a third country and seek a judicial review of that human rights claim. I'm going to explain what this means because that's where it gets quite complex, and that's when you begin to realize exactly how much work is required in relation to the suspensive claim process. Then we move on to section 42, and this is about how to submit and the determination of a serious harm suspensive claim. 43 is about a removal condition suspensive claim. 44 provides for an appeal on limited grounds to the upper tribunal. So forget the first tier tribunal when it comes to the suspensive claim and appeal process. Section 45 has a permission to appeal process if a claim is certified. Section 46 has a provision for out-of-time suspensive claims. And section 47 explains when a person can be removed during the suspensive claim process. Section 48 makes provision for the upper tribunal to consider new matters. Section 49 requires tribunal procedure rules and has all the timing, very short time limits for all of this in the appeal process. Section 50 then allows the Lord Chancellor to be the one to make those rules, and we have with Public Law Project engaged the Lord Chancellor in correspondence, urging the Lord Chancellor to permit the Tribunal Procedure Committee to make the first set of tribunal procedure rules. But we have heard back from the Lord Chancellor, and it says he's already drafted the tribunal procedure rules, and the TPC doesn't want to have sight of them. So we expect, as and when these sections are commenced, the Lord Chancellor will set out his amendments to the tribunal procedure rules, and then the TPC may consult on them thereafter and then make further procedure rules. And I doubt we will be consulted in that process because the Lord Chancellor has already said that he's undertaken the necessary consultation in the Illegal Migration Act. So just for some context on section 50, section 51 then ousts the supervisory jurisdiction of the High Court in the Court of Sessions, where judicial review challenges of certain decisions of the upper tribunal are only available on very limited grounds. And then section 52 redefines an upper tribunal judge to include a first tier tribunal judge. Section 53 provides for appeals and application for permission to appeal to be to SIAC rather than to the upper tribunal, where in the opinion of the Secretary of State, some information should not be made public. Section 54 is really crucial because it restricts a court or tribunal from granting interim remedies that prevent or delay or have the effect of preventing or delaying a person from being removed from the UK under this Act. Section 55 provides that an interim measure indicated, and this is where, remember when I was saying we were on a collision course with Strasbourg, well, what section 55 does is it says that if the European Court of Human Rights has indicated an interim measure under Rule 39 of the Rules of Court, well, that doesn't affect the Section 2 duty to make arrangements for their removal that the Home Secretary has, unless a minister determines that it does. Otherwise, a court or tribunal isn't to have regard to the interim measure. So really narrowing the scope of what a court or tribunal can consider. Section 56 then provides for the provision of civil legal services to people in receipt of a removal notice to make it in scope of legal aid and so that it's not means or merit tested. All right, that was really headline, just so you know what each section does. And then now I'm going to explain the actual process, because if you're like me, that didn't make too much sense the first time you looked at all the sections. So you need to really spend some time figuring out how they all fit together. So suspensive claims and appeals. First of all, why are they called suspensive claims? It didn't even occur to me that this was a question that I needed to answer in a seminar until someone asked me that last Friday when I was teaching a seminar. And I said, okay, well, they're suspensive because they suspend removal, and it's what they're called in the Act. So I think it's useful to just adopt that terminology so we're all on the same page. It is the only mechanism under the Illegal Migration Act to suspend or pause or stop someone's removal to another country. And that's really critical because throughout the passage of the bill, at first we had this inkling that maybe the Home Office was trying to stop the courts and tribunals from issuing interim remedies that would pause removal until a full human rights claim and judicial review had been heard. And then we were certain because they introduced that interim remedies clause during the passage of the bill. And so the only way that you can stop someone's removal is to go through the suspensive claim and appeal process. So it's absolutely fundamental if you want to help someone. And it's also the most urgent thing. If in the case of Rafi, for example, he comes to you and you're thinking, okay, should we work a little bit on your asylum claim for Afghanistan or your human rights claim for Afghanistan, or shall we make a human rights claim regarding Rwanda? The most urgent thing is to make a suspensive claim, because otherwise, in the meantime, while you're thinking which of those to do when you're preparing the paperwork and advising and taking instructions on those, Rafi's going to be removed to Rwanda. So unless that suspensive claim is in, he's not protected. What else to note about suspensive claims? They're not human rights claims. So any human rights claim Rafi does want to make about his removal to Rwanda is a separate claim that needs to be prepared. So again, this just puts an incredible burden on legal practitioners to prepare all of these different claims. But yes, a suspensive claim is only about two limited things, which we'll come on to. If you want to make any other human rights claim regarding the conditions in Rwanda, removal to Rwanda, how that impacts Rafi's human rights under the European Convention on Human Rights, you need to put in a separate claim. And it's not yet clear which application form the Home Office expects you to complete, or whether an application form does need to be completed and you have to go through the whole fee waiver process, or whether a new sensible process will also emerge with implementation of the Illegal Migration Act. It's also important to note that what the Act does is it says that human rights claim regarding removal to Rwanda, there is no right of appeal. And so your only way to challenge a refusal of the human rights claim in relation to removal to a third country is to go through the judicial review process. So very different to what we have now, where you have this ordinary automatic right of appeal to the first tier tribunal if you make a human rights claim regarding your removal. There are then two types of suspensive claims: serious harm suspensive claims, and that's where a person has to show that they face a real, imminent, and foreseeable risk of serious and irreversible harm, and a removal condition suspensive claim. And that's where a person is saying, I don't meet one of the 4 removal conditions in Section 2, you have it wrong. I don't come within the conditions to be targeted by the vast majority of provisions in this Act. So then what are the avenues for challenging removal? And as I said at the very outset of this training session, they depend on a person's country of nationality. And so that's another key thing that you're going to want to ascertain at the beginning. In this example, we had assumed that Rafi was an Afghan national. That means that this doesn't apply to him. But let's just say what this is. So for EEA, so European Economic Area, Albanian or Swiss nationals, which are listed in the new Section 80AA of the 2002 Act, which is to be inserted by the Section 59 of the Illegal Migration Act. None of this is yet in force. But they have 3 different methods of challenging. So if a person is going to be removed, let's take an Albanian national. Albanian national is going to be removed to Albania, their country of nationality or identity, and they make a protection or human rights claim. They won't have it considered unless exceptional circumstances apply. They have no right of appeal. And the intention of the Illegal Migration Act is for them to have no way to suspend their removal unless they say, I don't actually meet the 4 conditions in Section 2, in which case they can make a removal condition suspensive claim. So that means Albanians being removed to Albania have very limited ability to prevent removal. Then we have an Albanian, let's say, who's not going to be removed to Albania, but an Albanian who's going to be removed to Rwanda. If Rwanda if there's reason to believe that Rwanda will admit them, then they can bring either a removal condition suspensive claim, so I don't meet the 4 conditions in Section 2, or a serious harm suspensive claim, that they would face a serious irreversible harm if removed to Rwanda. They can also make a human rights claim and judicially review any refusal of that claim against removal to Rwanda. They don't have that option in relation to removal to Albania because, as we said, it's inadmissible. Okay, Then we move on to all other nationals, so anyone who's not a European Economic Area, Swiss or Albanian national. So any other country that's not listed in Section 80AA of the 2002 Act, which will be inserted by Section 59 of this Act. They cannot be removed to their country of nationality or identity. As we discussed, Rafi cannot be removed to Afghanistan, but if they're to be removed to a third country, like Rafi to Rwanda, which is where there's reason to believe they'll be admitted, they may also bring a suspensive removal conditions claim or a serious harm suspensive claim regarding their removal to that third country, i.e. to Rwanda. So Rafi has two options. He can either make a removal conditions suspensive claim or he can make a serious harm suspensive claim. Either one will suspend his removal whilst it's pending. Additionally, as with the Albanian to be removed to Rwanda, he can also make a human rights claim regarding removal to Rwanda. It doesn't suspend removal as we discussed, and there's no right of appeal. There's judicial review of it. And the judicial review does not itself suspend removal, I should add. Serious harm suspensive claims. So this first category of suspensive claims. So they only arise in relation to third country removals. As we said, the Albanian being removed to Albania doesn't have this option to apply for a serious harm suspensive claim. But an Albanian or an Afghan to be removed to Rwanda does. They have to show first that they would face a real, imminent, and foreseeable risk of serious and irreversible harm, and this is quite important, that the harm would arise before the period it would take for their human rights claim to be decided, including the time for the judicial review to be concluded. So the assumption in here is that they have also concurrently made a human rights claim regarding their removal to that third country, and that the serious harm that they're saying they would face if removed to that third country would arise before proceedings were concluded in relation to that human rights claim. Section 49 gives examples of, is that correct, 49? Gives examples of what constitutes serious harm, and they list death, persecution, torture. Sorry, it's 39, not 49. I thought that sounded wrong. Death, persecution, torture, inhuman or degrading treatment, punishment, or onward removal to a country where they would face one of those others. Those are examples. It's not an exhaustive list, but there is a list of examples that do not constitute serious and irreversible harm, such as persecution that doesn't come within Section 31 of the Nationality and Borders Act, or also where the standard of healthcare available to the person in the country or territory is lower than the standard that's available to the person in the UK, and any harm resulting from that different standard of healthcare. So it seems to me that this particular example is intended to undermine the kind of Papashvili in the UK kind of cases that, in the Secretary of State cases that were that are based on access and quality of medical care, including where it causes a rapid decline in the person's health. I think it's also helpful to note that Section 40, as we discussed, provides that the Home Secretary can amend the definition of serious and irreversible harm that's contained in Section 39, not 49, in regulations, defining any aspect of it, but also giving further examples. Removal condition suspensive claims. So this is the other type, the second type of suspensive claims. And there's a real question as to in how many cases will these types of suspensive claims be relevant. It's likely to be quite obvious once you take instructions, but there are some finicky parts of Section 2 that we have discussed and where instructions need to be taken. So where it's likely to be easy to tell whether a person meets some of the conditions are whether they have arrived on or after the date the act has passed, or if that date is moved forward, any other relevant date that's listed in Section 2. Did they enter or arrive with the appropriate leave or an ATA or entry clearance? Did they arrive in breach of a deportation order, or when are they an excluded person? Do they require leave and not have it? But the more complex issues arise in relation to, I think, whether they arrived by deception, as we were talking about in relation to the asylum ban. That is going to be one that will likely need to be argued if deception is accused. I have no idea of how often the Home Office might intend to look at these cases and think about deception, but reading recent articles in the news, it seems like deception in relation to students might be something that they're looking at. If students come in with entry or granted leave to enter as a student at the border, but then make an asylum claim, whether they will consider what the person said. And come to determine that they obtained that leave to enter by deception. The second complex issue is actually whether the person has come directly to the UK from a country in which their life and liberty were threatened for a refugee convention reason. And we talked about this very briefly again at the end of the asylum ban section. I think that for the vast majority of small boat arrivals, the Home Office will argue that they have not come directly because they've passed through either France or Belgium, and they haven't taken a small boat directly from Afghanistan. And so that is likely to be the kind of case where the Home Office doesn't accept it. But I think in each case, as we talked about, you need to take instructions to understand someone's travel to the UK and whether actually they were their life and liberty were threatened for a refugee convention in every country they passed. For example, was it did they take a flight from somewhere, and the 4 countries in which they passed through after leaving their country of origin or habitual residence, they also feared for their life and liberty for a convention reason. One on the basis that they're a woman, one on the basis of their political opinion, one on the basis of their sexual orientation, for example. So someone could theoretically have passed through several countries, but for different reasons, their life and liberty would have been threatened in those countries for a refugee convention reason, and it therefore wasn't safe for them. So a lot more work when it comes to evidence that they don't come within that condition of Section 2, but also a lot more work in terms of preparing the removal condition, suspensive claim, and appeal. But again, one to think about for Rafi, I think it's far less relevant, but let's just continue to move on. So step 1, we have the new suspensive appeal process. Under the new suspensive appeal process, it's really important to make an in-time claim. You only have 8 days to do so, beginning with the day the person is given the removal notice. And the Act says that the claim has to contain compelling evidence, and it has to be made in a manner that's not yet prescribed, in a form that's not yet prescribed. We have to wait for regulations to see what these say. Obviously, 8 days is an incredibly short period of time to expect a person without a legal representative to find one, give instructions, gather evidence, and make the claim. So the Home Secretary has a power to extend the time for a person to make an in-time suspensive claim. And I think in the vast majority of cases, particularly where people don't have access to legal representation, it will be important to ask for that extension. However, if someone doesn't make an in-time suspensive claim, they become subject to removal. And so it's a risk to balance. Another really important point is that details of all relevant matters should be raised within that 8-day claim period. If they're not, they're considered to be new matters under the Act. And I'll explain why in a second that's quite problematic. So out-of-time claims, still step 1, still lodging the claim, but what if that 8-day time frame is missed because you couldn't gather the evidence, because you weren't instructed until after the 8 days had passed, because a person couldn't receive legal advice? Well, if the Home Secretary considers there were no compelling reasons for not applying within that 8-day claim period, a person can still ask the upper tribunal to consider it and whether there were compelling reasons, and the upper tribunal has to decide within 7 working days, and also a person has to apply to the upper tribunal within 7 working days. If the upper tribunal says no compelling reasons, then there's very limited grounds to judicially review that decision of the upper tribunal. Really importantly, again, even once an out-of-time claim is pending, it pauses removal. So again, very important to balance raising all the relevant matters you want to raise in the claim and doing so within the 8-day period where possible, with getting that appeal lodged as quickly as possible if you miss the 8-day period. Now, step 2. The Home Secretary has to make a decision on the suspensive claim, and she has 4 days to do so, beginning with receipt of the suspensive claim, unless the decision period is extended, and she can extend both the claim period, so the 8-day period, and her 4-day decision period. There's 3 things she might do: accept the claim, refuse the claim, or refuse it and also certify it as clearly unfounded. Now, if the claim is accepted, brilliant. The person can't be removed from the UK to whatever territory or country was listed. So Rafi cannot be removed to Rwanda if his claim is accepted. But if there's a change in circumstances, including if he makes a human rights claim or challenges by judicial review refusal of that human rights claim, the Secretary of State can revise her decision and instead decide to refuse his suspensive claim. So bear that in mind. There's always the opportunity for the Home Secretary to go back and change things if things go wrong with the human rights claim or there's other change in circumstances. If the claim is successful, it's still really, really crucial to remember that that doesn't get Rafi or anyone out of the Section 2 duty to make arrangements for their removal. The Home Secretary is still under a statutory obligation, even if someone is successful in the suspensive claim or appeal process, to make arrangements for their removal as soon as reasonably practicable. And so just because he won't be removed to Rwanda doesn't mean she won't try to remove him to a different country if there's somewhere else that's willing to admit him. Then we come to the second scenario. Rafi's claim isn't accepted, it's refused, but it's not certified as clearly unfounded, so it's not the worst possible outcome for his case. Still, a notice of appeal with compelling evidence has to be given to the upper tribunal within 7 working days. The only available grounds are those that we talked about, either that the serious harm condition is met or that the person does not meet the removal condition. So one of the 4 conditions doesn't apply to them. The upper tribunal then has only 23 working days, so an incredibly short period of time, beginning with the date on which the appellant gives notice of appeal, to make a decision. If the appeal is dismissed by the upper tribunal, there's still the opportunity of onwards appeal to the Court of Appeal in the UK or the Court of Session in Scotland, sorry, England and Wales, or Court of Session in Scotland. New suspensive appeal process, step 2, yes. So this is the third possibility. If the claim is refused and it's certified as clearly unfounded, then there's no automatic right of appeal. Then we get into the permission to appeal process. And instead of having an automatic right of appeal, Rafi has to ask the upper tribunal for permission to appeal within 7 working days. And also, the thresholds for obtaining permission to appeal are raised only if, for a serious harm suspensive claim, the upper tribunal considers there's compelling evidence, again, that a person meets a serious harm condition and the risk is obvious. So quite a high standard. For removal conditions, there still has to be compelling evidence. Importantly, permission hearings will only take place on the paper, so there's not going to be an in-person hearing unless the upper tribunal considers that an oral hearing is necessary for justice to be done in a particular case. So again, quite a high standard, one would think. I think that's... So new matters. If we move on to new matters, this is why it's so important to raise all the relevant matters within the 8-day claim period. Because if not, then you have to raise them as a new matter. And although the upper tribunal can take into account any matter it considers relevant to the substance of the decision, if it's a new matter, the Home Secretary has to provide consent. And she can only provide consent if there were compelling reasons for the person not having provided details of the matter before the end of the 8-day suspensive claim period. So that initial 8-day period following the removal notice. She has 3 working days to come up with a decision after the day on which the new matter is raised. If the Home Secretary refuses consent, that's not the end of the line. The upper tribunal can determine instead whether there were compelling reasons for the person not to have provided details of the new matter before the end of the claim period. But there's no right of appeal if the upper tribunal finds against a person that there were not compelling reasons. And there are only limited grounds on which the upper tribunal's decision can be judicially reviewed. And these are the limited grounds. So there Section 51 of the Act specifically says the upper tribunal's decision is final and not liable to be questioned or set aside in any other court. There can be no judicial review except so far as the decision involves or gives rise to a question as to whether A, the upper tribunal has or had a valid application before it, B, the upper tribunal was properly constituted for the purpose of making a decision or dealing with the application, or C, the upper tribunal has, again, acted in bad faith or in such a procedurally defective way as to amount to a fundamental breach of the principles of natural justice. Again, very high thresholds for the judicial review of upper tribunal decisions. So basically, single bite of the cherry, skipping over the first tier tribunal, and very difficult to challenge the upper tribunal. Then we move on to when the duty to remove is suspended. So as I was saying, when a person has made an in-time suspensive claim, it's suspended until the Home Secretary has made a decision. Where a person has made an out-of-time suspensive claim, again, until there's a decision as to whether there was compelling reasons for claiming out of time. Where a person has made an out-of-time decision and the Home Secretary considers there were no compelling reasons, whilst the upper tribunal is making their decision. And where a person has made an out-of-time claim and either the Home Secretary agrees, yes, there were compelling reasons for claiming out of time, or the upper tribunal says there were compelling reasons, until the Home Secretary has considered the suspensive claim. Then where this suspensive claim is refused and it's not been certified as clearly unfounded until any appeal is determined or the time for lodging an appeal has expired, and also where a person successfully appeals to SIAC. But as I say here at the end of the second bullet point, the duty to remove still applies. So even if a person is successful in all of this, that doesn't mean that they get out of the Section 2 duty to remove. And in fact, if they have a change in circumstances, that can be considered and result in a different decision from the Home Secretary or a new removal notice being issued. So what can the court or tribunal do to stop removal? Very little, in 2 words. Interim remedies, we've discussed, it cannot grant that prevent or delay removal, and then interim measures, it has to wait for a ministerial decision about whether it can take into account an interim measure indicated by the European Court of Human Rights. And the ministers may have regard in coming to that decision as to whether, for example, the UK was given an opportunity to present observations before the interim measure was indicated. As a quick summarizing of it, we have here the process, so large suspensive claims, it can be in time or out of time, and then we have a decision on it, permission to appeal if the claim is certified, then we have an appeal deadline, an upper tribunal decision, and onward appeal to the Court of Appeal. Okay, moving on to legal aid. It's worth noting that the Act does contain provisions to increase the scope of legal aid in England and Wales, and also in Northern Ireland. Focusing on England and Wales for one moment, where a person receives a removal notice, from that point, there's a new paragraph 31C that's inserted into Part 1 of Schedule 1 of LASPO. As I was saying at the beginning, I think before a person receives their removal notice, they should be eligible for advice in relation to making an asylum or protection claim under paragraph 30 of Part 1, Schedule 1 of LASPO. The problem is finding a representative with capacity to take on that case, particularly when it's all happening so quickly, for example, at Manston, and there's no duty advice rota scheme. But if someone does receive a removal notice like Rafi, even though he's not had any advice before his screening interview, it is the case that legal advice following the removal notice and throughout the suspensive claim and appeal process is in scope of legal aid. Advocacy proceedings in the upper tribunal are also brought into scope of legal aid. And additionally, there's an increase in the scope of legal aid for people who want to judicially review the human rights claims, even though there's a separate suspensive claim process, where so long as the human rights claim is on the basis of Article 2 or 3 of the European Convention on Human Rights. Now, what some recent regulations that have come out in the past few weeks have done is amend both the means test and the merits test. The Illegal Migration Act removes the merits test, and what the recent regulations do is remove the means test for both advocacy proceedings in the upper tribunal and civil legal services. Additionally, the regulations amend the 2013 remuneration regulations to actually do what the government proposed it was going to do in its consultation response on illegal migration bill legal aid fees, which is increase that work, that specific work following a removal notice, by 15%. The judicial review work on human rights claims is not increased by 15%, just to flag. Okay, questions on the suspensive process. What were some key points that we should advise Rafi in relation to the suspensive claim and appeal process? Let me just run through these first to summarize, and then I'll take any questions that people have. So first, the most urgent thing to do, as we discuss, is to get Rafi legal help in relation to a suspensive claim and appeal. This is even more important, I would argue, than dealing with the detention, which of course we don't want Rafi to remain in detention. So if there's anything we can do to get him out of detention, of course we should do that. But this has a very tight time frame, and we don't want Rafi to miss his ability to make a suspensive claim in time. As I said, an extension request can be made from the Home Office, but I have no idea whether the Home Secretary will grant it before the end of the 8-day period, particularly with someone like Rafi who has only 3 days left to claim. Then we have instructions. It's likely that the most viable claim that Rafi is likely to make is not a removal condition suspensive claim, given that he's come on a small boat. It's likely that the most viable claim that he has is a serious harm condition suspensive claim, and that he can also make a human rights claim, both in relation to Rwanda. But of course, take instructions from any person about a removal condition suspensive claim to figure out if they even come within the Section 2 conditions. Then we need compelling evidence. I have no idea right now what that means, but it will also need to be filed both as part of the claim process and the appeal process. And then wherever possible, as we said, try to claim in time, try to appeal in time. Particularly, we don't want to have recourse to appealing out of time. That needs to be done as soon as possible to protect Rafi's position and make sure that he's not removed to a third country. That position is not protected until a suspensive claim is lodged, even out of time. And then we have interim measures of the European Court of Human Rights still pursuing, but as we said, ministers can require courts and tribunals to ignore them. We will have a separate seminar about making interim measure applications, I'm hoping, so we're not going to cover it in any depth today. All right, questions from the chat. Alice, is it a 4 or 8 calendar working days? The Act says 4 days, so calendar days in my interpretation. Marina says, do legal aid providers need a specific legal aid contract for removal notice work? Marina, the legal aid agency, is at the moment consulting on changes to the present immigration asylum specification to make it so that it encompasses this work. There are going to be new provisions that are proposed in relation to the detained duty advice scheme, but primarily it's what we've discussed today. Can the upper tribunal consider the human rights claim on appeal? There is no appeal for the human rights claim, Agnes, so it cannot. There's only judicial review. Mauricio, how does this affect Article 8 applications for those who have entered either through Ireland or on a fake passport? And this is what I said, my headline point at the beginning about Section 2 is it's not about small boats, it's not about dangerous journeys, it's about anyone who meets the Section 2 conditions. If someone comes in and they meet the Section 2 conditions because they have passed through, they come across the land border between the Republic of Ireland and Northern Ireland without having the appropriate leave, entry clearance, ETA, then they could still be subject to the Section 2 conditions and therefore to the Illegal Migration Act if it comes into effect. So yes, Article 8 applications, because it would be a human rights claim regarding their return to their country, would be inadmissible, and the rest of the provisions apply. Juliet has said, I'm curious to know why serious harm suspensive claims apply to third country removals and not to a person's country of nationality, given that this would mean the UK accepting in some cases Rwanda to be associated with the risk of serious harm. My interpretation is because it didn't want to consider serious harm conditions claims made by Albania in relation to removal to Albania, but that's just my 2 cents. Really difficult to know why the government does anything. Francis, is there any indication of what will happen to someone who is removed to a third country and then is refused their claim? Will they be removed back to the country of origin? I mean, one would hope not, because that is onward refoulement if they have a risk of persecution there. So it will depend what the third country does in relation to their claim, and whether it has a proper refugee status determination if they are in fact a refugee. Will they be accepted back to the UK if their claims are successful? I don't know exactly what you mean by that, but in most circumstances, the suspensive claim process the suspensive claim process only applies to people who started in the UK. So it's not the case someone's removed to Rwanda and then starts a suspensive claim process. I hope that helps, but if you have a particular situation in mind, I'd be happy to chat about it another time. I just want to get through the last few sections in the last 10 minutes that we have, and I'm sorry that I'm speeding through it. I shouldn't have taken a 10-minute break. Miscellaneous. So this is what I've called these last few sections of the Act, but we have age assessment, and I think June asked a question about age assessment before. There's obviously different provisions in the Nationality and Borders Act on age assessment, and the Illegal Migration Act builds and in some cases undermines those provisions. So it's a very complex sort of Kafka situation. What we have with Section 57 is it says for age assessments under the Illegal Migration Act for people who come within the 4 conditions of Section 2, if a relevant authority decides a person's age, then there's no right of appeal. And what the Nationality and Borders Act did was it introduced this new appellate system for age assessment appeals, which has not yet been commenced itself. But the Legal Migration Act says basically if that were to ever come into effect, that's not going to apply to IMA age assessments. And instead, it has judicial reviews of age assessments instead of the appeal process, so much like now. But interestingly, the judicial review doesn't actually prevent any duty or power to remove a person. So as we said, the only thing that stops removal is the serious harm suspensive claim process. Even where the age assessment is in dispute, it doesn't stop someone being removed to a third country, like Rafi being removed to Rwanda, if this is ongoing. It also limits the judicial review so that the only relief that the court can grant is on the basis that the decision was wrong in law, not that the court or tribunal thinks the decision was wrong as a matter of fact. So really important in terms of the scope. Section 58 then also starts to unravel and change some of the scientific age assessment side of things. Where there are no reasonable grounds for refusing consent, regulations can say that the damage to credibility that we talked about, which is in the Nationality and Borders Act, doesn't apply, but also that a person can be treated as if they were over the age of 18. So introduces this presumption of over the age of 18. And that's quite problematic if someone refuses a scientific age assessment and then they're presumed to be over the age of 18, in which case the duty to remove applies rather than the power. You can see the cascading implications across the Act. Then Section 59 extends the current inadmissibility process for asylum claims from the EU, but also to include human rights claims. And this seems to me to be quite mad because it means that European nationals making any human rights claim, any Article 8 human rights claim, can also have those claims be inadmissible, but it's not yet enforced, and I don't know whether they will ever bring that aspect of it into force because it really seems quite mad. Section 60 then requires the Home Secretary to determine an annual cap, as we talked about. 61 is the report on safe and legal routes, and Section 62 amends Section 8, as we discussed, to provide for damaging a person's credibility if they refuse to give access to an electronic device. General. I'm not going to go through it because I think we've gone through the important bit, which is Section 68 in relation to commencement. There's then two little schedules at the end of the Act. One is to say the countries to which a person may be removed to, and you've got it. The Republic of Rwanda is one of them. But note, as we said, Section 7.1 also says that if in general there's no risk of persecution or it wouldn't contravene the rights under the ECHR, the Home Secretary can also add more states. Schedule 2 relates to electronic devices, and that brings us close to the end, just to have a little bit of a wrap up at the end of what we've discussed today. So really important to remember that the fundamental part of the Illegal Migration Act is to remove certain people from the UK. Those certain people are the people who meet the 4 conditions in Section 2. It's a duty when they're adults, and for children who are unaccompanied, it's a power that becomes a duty on their 18th birthday. We then have the inadmissibility process, which I would call the third inadmissibility regime. If you think of the rules, the Section 80B inadmissibility regime, and now the Illegal Migration Act inadmissibility regime. But it's permanent, and it's important that no trafficking, no modern slavery claim, no human rights claim, no judicial review will suspend removal. And judges' hands are also tied because they cannot grant interim remedies that stop removal, and they're also limited to the extent they can take into account interim measures indicated by the European Court of Human Rights. So then where does that leave people? In limbo, because sections 30 to 37, which we talked about in depth, they're already in force, and they say, unless some of those limited exceptions apply and discretion is exercised to grant someone limited leave, they cannot be granted limited leave to enter, remain, or citizenship. We then have detention provisions, which create indefinite detention powers, including for accompanied and unaccompanied children with limited judicial oversight and no first-tier tribunal bail. So now we will have to have recourse to Home Secretary bail and also habeas corpus in the first 28 days. So very limited as the ways to challenge it. And finally, the fast-track suspensive claim process, as we've just gone through in great depth, it is intended to be quite complex. It's intended that if a person doesn't have a legal representative, it will be very difficult for them to raise all the relevant matters. If they don't raise the relevant matters or apply in time, then they have to have increased thresholds, increased processes through the Home Secretary or through the upper tribunal, and they basically have a single bite of the cherry to get those correct. Otherwise, there's only judicial review on very limited grounds of the upper tribunal's decisions in relation to permission to appeal or out of time or new matters being raised. And then in the appeal itself, it's a very fast track appeal, a short time for legal representatives and applicants to fully prepare their serious harm cases, particularly if you're thinking about also making a human rights claim and judicially reviewing that. And then even if you're successful at the end of that, whether in the upper tribunal or the Court of Appeal, there is still the Section 2 duty to remove looming over your client's head, so that when you think the case is done, in fact, it's not done, because a Home Secretary might come up with a new state to try to remove them to, or a change in their circumstances, which would result in them being removed to a different state. And then finally, I mean, one would hope, as we said at the very beginning about commencement, that the rest of the provisions are not commenced. And the reason we would hope that is because it's clearly a reputational failure. It's clearly in breach of so many international legal obligations, which we said throughout the course of the passage of the bill. It shows, as we were talking about, that the UK doesn't intend to interpret its treaties in good faith, that it doesn't abide by its word. And so why would the European Union, for example, come to a returns agreement with the UK when it's acting in this way? And it's also likely to put the UK on a collision course with both the European Court of Human Rights and the Council of Europe. I have really rushed through the end of that presentation there just to get through in time, because I don't want to take up any more time of any more of people's time, but I'll just take a quick look at the chat to see if there's any last minute questions that I can answer in the couple of minutes that we have left. Louis says, says, if you win on a suspensive basis, aren't you in practice going to succeed in a human rights claim, although you still need to make a distinct human rights claim? Good question, but of course there's two suspensive claim processes. There's a removal condition suspensive claim process, which has no regard to human rights or serious harm that you might suffer, and there's the serious harm suspensive claim process. In the serious harm suspensive claim process, yes, I agree. It's likely to be very relevant to a human rights claim that you would face it, serious and irreversible harm before any human rights claim or judicial review was decided. But yes, you would still need to make a distinct human rights claim. It doesn't help you though, because you also need to think about doing that in relationship with Section 30. Otherwise, you get nothing out of the human rights claim, given the person is still bound by the Section 2 duty to have them removed. Dominic has said, what effect does Schedule 1 have on those whose nationalities are not contained in the list? I'm not sure what that means, but basically everyone who isn't a Section 80AA national, so not a EEA national, not a Swiss national, not an Albanian national, can be removed to a Schedule 1 country. They cannot be removed there if that's their own country, of course, if that's what you're getting at, Dominic, but they can be removed to any third country listed in Schedule 1. Also, any EEA, Swiss or Albanian national can also be removed to a Schedule 1 country in addition to their own country. The only reason they can't be removed to their own country is if there are exceptional circumstances. Mauricio has said, so even though the differentiation of Group 1 and Group 2 refugees was removed with NABA, it basically still exists in the IMA. No, this is much worse than the Group 1 and Group 2. Group 1 and Group 2 still meant that people were getting refugee status. They were just having it with different entitlements. This is not about people getting refugee status at all. It's not being recognized as refugees and being removed and being left in limbo without any status or any leave. I think that's all the questions, unless there is anything else that anyone has, but we're now 1 minute over.
There's just a suggestion in the Q&A session that you should launch a podcast because that was a very, very insightful session. Thank you, Zoe. I don't think there are any more questions. I have some concluding words if you're happy for me to go ahead.
Absolutely.
Thank you so much for the brilliant session. I hope that everybody has found it as helpful as I have. I also want to echo anonymous attendee in the Q&A in saying that you did an amazing job of explaining brilliantly a pretty complex piece of legislation. So well done. I've put a link to a survey in the chat. Please do fill it out if you have time. It only takes a few minutes. As we've mentioned, we'll be running other training on the Act, and our goal is to bring the whole sector as up to speed as much as possible. So your feedback would be really useful for us for the further sessions. You can also enter yourself for a prize draw. If you fill out the survey, the prize is a voucher for more ILPA training, so that's an added bonus. As I've mentioned before, the materials and recording will be publicly available on the ILPA and Greater London Authority website. I've also popped in the chat a link to session 2 of our training series. The session is next Wednesday on the 8th of November, and it will cover entry, settlement and citizenship. Do look out for the rest of the sessions on the Act, which will be announced soon. And again, huge thanks to Zoe and the Greater London Authority for making this session happen. And thank you all for attending. I hope you enjoy the rest of your day. I think everything, yes, there is no more questions. So I'll stop the recording here and stop the session. Thank you again, Zoe. Bye.